30? Why? 14 matter. You are making this prayer on behalf of Mr. Bunny for the respondents. Have you taken the consent? A prayer is made on behalf of Mr. K.K. Nandi for an adjournment in the matter on the ground that he is out of station today. Prayer is not objected to by Mr. S. Boni. Prayer is not objected to by the learned counsel for the petitioner. Also, accordingly, in view of the above positions of para, registry to list this matter again on 9/9/2025. 9/9. Yes.
May I please, Your Lordship, with consent on the other side, I beg to mention item number 7. Matter may be adjourned for a week.
Why? You're making this prayer on behalf of the petitioner. But the matter was heard last date. Mr. Todi was here.
Mr. Todi is unwell today, my lord.
Prayer is made on behalf of Mr. A. Todi. Have you taken the consent of the other side?
Yes, my lord.
Waiting for the respondents.
Prayer is made on behalf of Dr. Ankit Todi, learned counsel for the petitioner for an adjournment in the matter on the ground that he is indisposed. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter after 4 weeks on a date to be fixed by it.
So glad.
For one, my lord, I am praying for today, okay, accommodation for that day,
Why?
fixed at 10:30, my lord.
Come back, we are here.
Please, Your Lordship.
Yes, Mr. Vora.
Your Lordship, on last occasion, Your
Has the
Lordship-
money been released?
No.
Not even to the main contractor. Why?
Yeah.
Between? So there is already an order that if the money is to be paid, that has to be paid by taking into account his dues. There is an interim order here on 11/4/2023. Okay, fine. So against that foreclosure, you have instituted the arbitration procedure. So is this utility shifting also one of the claim in the arbitration proceeding? Yes.
Lordship, if Your Lordship perusses through 9.2, which is at page number 38, if I may just take Your Lordship to that particular clause, that is totally independent of whatever claim the contractor is having with the NHIDC. If I may just read it out, Your Lordship. Shifting of obstructing utilities.
Okay. File a civil suit against the contractor.
No, Your Lordship, why? What is the difficulty here? I tell Your Lordship. Here, the conduct of the NHIDCL and as well as the contractor.
You are
Very
a non-entity as far as the NHIDCL and the contractor is come. You are a subcontractor of the contractor.
I'm not a subcontractor. That is why
Show me.
I'm a utility contractor. As per 9.2.
Mr. Bora, this utility shifting is not on you. It is on the contractor.
Your Lordship, if I may just
Read.
it out. The contractor shall, in accordance with applicable laws and with assistance of the authority, which is NHIDCL, cause shifting of any utility, including electric lines, water pipes, and telephone cables, to an appropriate location or alignment if such utility obstruction adversely affects the execution of works or maintenance of the project highway in accordance with this agreement. The actual cost, this, your lordship, is important. The actual cost of such shifting as approved and communicated by the entity owning the utility shall be paid by the contractor and reimbursed by the authority to the contractor. Now, how this particular utility will be shifted? Because the contractor is only involved in road construction, not for utility works, your lordship. Utility works will have to be bared. It has to be borne by utility contractor who is.
Okay, show me your appointment as the utility contractor.
Yes, your lordship. I'll just. Page number 40, Annex 3. Page 41 is the payment terms, lordship. There, highway. After completion of work, bill shall be submitted to Ramki TK JV along with the supporting documents such as joint record, certified measurement and reconciliation statement of the issued materials, etc. The same shall be verified by authority engineer, and authority engineer is NHIDCL appointed.
By
And
our authority engineer.
By our authority engineer is NHIDCL.
Okay, whoever it is.
As per the contract agreement, and put to NHIDCL for payment. The net RA bill amount will be released to you immediately only after receipt of from a authority. Here, what has happened at paragraph number 7 of my rate petition, if your lordship peruses through paragraph number 7 of my rate petition, that is why I'm actually stressing on conduct. As per 9.2, the.
Okay, show me.
Yes. Page 9 of the rate petition, the petitioner humbly begs to state that the petitioner has successfully executed the said works with due diligence to the satisfaction of the utility owning agency APDCL. The petitioner is a empanel contractor with APDCL. And first running account bill number 1 amounting to 88 lakhs was paid to the petitioner after making the necessary statutory deductions.
Who has paid this amount to you?
The contractor. After getting paid. But as per 9.2, the contractor should have paid me first, then get a reimbursed from the NHIDCL. It may please be noted herein that the EPC contractor had released the said RA bill number 1 for 3 years for the said period so and so, whereas the payment was released by NHIDCL to the EPC contractor in 2017 itself. It is further submitted herein as per Article 9.2 of the contract agreement executed between NHIDCL and EPC contractor. It is clearly stated the actual cost of such shifting as approved and communicated by the utility owning the entity owning the utility shall be paid by the contractor and reimbursed by the authority to the contractor. It is on record that said clause was clearly violated both by NHIDCL and the EPC contractor.
How?
Your lordship, because here, as per 9.2, their contractor should have paid me first, then get it reimbursed. The bills as well as the entity owning the utility certifying that yes, this is to our satisfaction. That has been done. The authority engineer.
So, Mr. Bora, what I understand is that once the utility shifting is done to the satisfaction of the concerned authorities, the contractor has to pay you.
Yes.
And thereafter, he will approach the NHIDCL authorities.
Yes.
He has not paid you.
He has not paid me because, in fact, NHIDCL's conduct here, what is important here, they have actually, the contractor themselves, they have asked the NHIDCL to directly pay me.
Where is that?
That is, your lordship, page 42, your lordship. This is letter dated 9/1/2019. Annexure 4, page 42. Therein, as per the, I'll just read out, your lordship, from second paragraph onwards. As per contract agreement clause number 3.7 and 9.2, we state that the contractor shall be responsible for procuring of all power, and the contractor shall, in accordance with the applicable laws and assistance of authority, cause shifting of any utility if such utility or obstruct adversely affects the execution of work or maintenance of the project highway in accordance with this agreement. The actual cost of such shifting is approved and communicated by the entity owning the utility shall be paid by the contractor and reimbursed by the authority to the contractor. In the event of any delay in such shifting.
Come to page 45, the reply.
Yes, lordship. Paragraph number 4 and 5, lordship. It has been observed, I'll start from that line, your lordship. The utility shifting work has enormously delayed and the progress of work is slow, yet despite various actions being taken by the authority for expediting the work. It has been observed in several cases that the utility shifting bills are released to EPC contractors, but the same are not paid to the utility shifting subcontractors, resulting in delay in utility shifting works. Since contract agreement does not have the provision of releasing utility shifting payment directly to the utility shifting, but contractors, therefore, it is recommended that approval of competent authority may please be taken in this regard so that the utility shifting work can be expedited. And in this regard, next page, Your Lordship, page 46. The competent authority writes to the general manager, paragraph number 2, in this regard, it is requested to obtain undertaking from the EPC contractor that they will not make any claim on account of any delay in shifting of utility by the utility contractor, and the same may be forwarded to this office at the earliest. Next page, Your Lordship, the contractor themselves.
Where is this 15/3/2019 letter?
For page 49, Lordship, Annexure 8, they gave an undertaking that the payment may be made directly to the subcontractor or utility contractor for that matter. They have no objection. In the earlier page 42 itself, page 43, they have clearly written that the payment may be made directly to the petitioner. And they gave an undertaking to that effect also. Page 49.
Yes.
And
Yes.
the money is still with NHIDC.
Lordship of my
Para 8. So you say that this amount is till 15/3/2019. Have you paid the amount that is due till 15/3/2019 directly to the petitioner? What is after 15/3? Fine. There is no undertaking. But till 15/3, have you cleared the amount? What is the dues till 15/3, Mr. Bora, you are to receive?
Till 15/3, Your Lordship, around 2 crore something. 2 crore. In fact, the amount as such.
3 crore 41.
No, that is the total amount.
Total amount.
Total amount.
But
2 crore
till
21
15/3, what is the amount due?
21 lakhs. 8,000. That is what the prayer portion.
Yes, Mr. Dury. You have given an undertaking that till 15/3/2019, whatever is there to be directly paid. Was it paid? Fine. Fine. Is this admitted? You have admitted 3 crores. Out of that 3 crores, how much is receivable by the petitioner?
As per his lordship, 2 crore.
No, till 15/3. There is no problem till 15/3 according to your affidavit. So whatever is there, release it. Baki, the rest will be, he will take appropriate steps with the
That
authority.
is the only amount. 2 crore 21. That is my
How
prayer.
much amount is lordship?
Just have that instruction. Can we have it at 2? Or we'll have it on another day? You have all agreed that till 15/3, whatever dues is there is required to be released. You agree to that, Mr. Talura?
That in respect of that undertaking, lordship.
Only the undertaking. Till the undertaking, whatever bills are there, release it. Mr. Dury, you can have no objection with regard to page 49. It's your letter undertaking from you. Whatever bills, admitted bills are there, that can be released. The rest will not be.
And also their own letter at page 42. 9/1/2019.
That led to this.
That
Fine.
led to that.
So we'll not go beyond this. If there is anything, he will institute proceedings against you. The admitted bills only. 3 crores is admitted by them. Overall total amount 3 crores is admitted. And if whatever is there till 15/3, that they'll release. That's all. Full stop. They heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. R.K. Talukdar, learned standing counsel, NHIDC, appearing for the respondents number 2, 1, 2, 3, and 4. Also heard Mr. S.K. Dury, learned counsel, appearing for the respondent number 6. 6 and 7. The work is by 6 only here. Oh, it's a joint venture. 6 and 7. Full stop. The parties after hearing the matter at some length, the parties to the proceeding have arrived at a consensus that the amounts due to the petitioner herein as the utility shifting subcontractor till 15/3/2019 can be released to him. Correct. So the petitioner, learned counsel for the petitioner, has submitted that in terms of the undertaking given by the respondent number 6 and 7 before the NHIDCL authorities, the bills submitted for utility shifting by it can be released directly to the petitioner by the NHIDCL. Also, Mr. R.K. Talukdar and Mr. S.K. Dury, learned counsel, appearing for the respondents, submit that they be given a week's time to complete their instructions in this matter. Also, prayer accepted, a registry to list this matter again on आप तारीख है पढ़ी 9/11/9/2025.
Highly obliged.
Just get that instruction. Rest we will. It's disputed. We will not go there. And there is another judgment that subcontractor NHIDCL. I think I was appearing the NHIDCL side.
This is the single judge judgment, and this is a retective. That is different because he was civil contractor, and we had no privity. There was no privity of contractor. In fact, in this case also, I wouldn't have troubled your lordship, but the facts of that case is different, your lordship. There was no communication, nothing of any sort between NHIDCL. And in that case,
See, Mr. Bora, if there is no agreement between the parties, we will not come in. We will not pass a mandamus here. Because rightly so, there is no privity of contract between you and... I know that. But if there is an agreement between the parties, we will come in, or we will have to remand you back to the civil court.
Basically, your lordship, let them take the instructions.
Otherwise, there is no privity of contract between the... because what will happen if they release that amount tomorrow in the arbitration, the amount is again brought in. You are not there. That is also part of the claim there. So that has process.
First, they should reimburse us as per
That's what I'm saying. For that, you go before the civil court if they have not done it. File a money suit for recovery of that amount. If there is an agreement, we will come in. If not, Mr. Bora, we are remanding back. Right. Yes. Huh. Hmm. I'm sorry. I want the amount today. What amount you are paying? You are liable to pay. I just gave you an opportunity to make a quantification and inform this court. Nothing more, nothing less. We want that quantification, or you call your competent officer. We will have a discussion with it. No adjournment. Don't be so casual in such matters. Categorical undertaking by your counsel here. There is an undertaking by your counsel. How can you go beyond that undertaking? Have you read the order? The order was passed in your presence. Then undertakes that the compensation amount payable to the petitioner would be finalized in the meanwhile by the ABSNL authorities. So finalize it, tell me. No, today, 2 o'clock. Yes, Mr. Soike. What is it? He cannot. Vinod Kumar. Yes, Mr. Soike. This is National Highway. And yours is right to fair compensation, 23. But what about section 51 there?
Well, this 2013
Uh,
H.
under the, this is your case, it is National Highway. That's what I'm saying. Under 13 Act, what is the provision? 13 Act only.
Award is made under section. Highway Act is concerned H. Mandates that any dispute
Hmm.
on the provision.
Hmm.
Here it is not shown. Agree interest.
Hmm.
Own melody is not a. What is melody who might be interest or the amount of compensation.
Mr. Soike, just for my clarification, the compensation that has been determined is not disputed. It is the manner who will receive the compensation that is under dispute here.
In paragraph 13, what he says. Person interested.
Hmm.
While the order was passed.
Hmm.
Thereafter, he files this. The application leads to know whether he wants a reference or not. Says the legal heirs of so and so. So therefore, the court has, the collector has sought to hear the matter. On the order that was passed earlier is, as far as the land valuation is concerned, we will be getting it, etc. That is civil court. So he has all the option to go to the civil court, but to the.
It's already before the principal.
The land valuation is concerned with regard to the others.
Hmm. That has already been referred.
Already they have approached the civil court in themselves.
But the petitioner is not a party there.
Yeah, I think he is a party. He is a party.
Okay. Yes, Mr. Sama.
Yes, so far as the civil court is concerned, as my planner stated, I have no instruction to that effect. Well, my whole submission is this, page 40 of my petition.
Page 40.
The parties have not arrived at the it is decided to institute a suit in the Court of District and Session Judge with regard to the payment of The ADC cannot direct the parties to file a suit. His duty is to refer the matter to the district judge under section 6.
Have you applied for that? Have you applied for reference?
That is, ADC is to refer.
No. Have you applied that we are not agreeable with the,
Yes, yes.
where is that?
That order was passed on.
No. Where is your application to that effect? If I have understood the facts correctly,
Page 23. Man.
so the dispute is with regard to Jirat, with regard to the building and the houses.
Distribution of compensation.
Compensation. So the compensation was determined, including both the original Patadas, Upendas and Dilip Das, I suppose. Ojit Das. So an amount was released. A lower amount was given to Upendas, but a higher amount was given to Ojit Das. This was objected to by you by saying that, see, this house, we had built it together and we have been possessing it together. But after the death of your husband, this was not done. initial order, this was not considered. Then you filed a further application, on the basis of which a further hearing was held. And therein also the ADC has come to a view that he tried to compromise the matters between you and you have not compromised. So the only way out is for you to approach the civil court. Rightly wrong, he should have referred it. But that's the order, if I've understood it correctly. So what I get is the quantum of compensation determined for the land and the property is not in dispute.
Yes.
What is in dispute is what is the share out of that to be received by you. Mr. Soike, am I correct to that extent? The quantum of compensation that has been now determined is not in dispute. Mr. Sharma does not dispute it. Say 1 lakh rupees. Pata is not, it's a Esmali pata. That's what I'm saying, mister. That's what I'm saying. Say the land is 1 kotha, for example, 1 lakh rupees. This 1 lakh rupees is not disputed, right? 1 lakh rupees rightly assessed. What is in dispute is whether you will get 80% or you will get 20%. Whether he will get 80% or he'll get 20%. They share.
And in my
It's not been partitioned. It has to be seen.
second evidence, court found that the
Which court?
collector.
Collector cannot do that. If there is a dispute, prima facie he cannot do it. If there is a dispute, then with regard to apportionment, then that will have to go before the court of the principal judge. Authority. The authority here, if you can come to page section 76. If you can come to 76, it is exactly a situation which arises in your case.
Provisions
Mm.
with regard to the Act.
Mm.
Well,
Mm.
Four.
Mm.
Or
Mm.
26, if it is application under 6, it is a discretionary. He has said.
But can he decide the apportionment? He cannot. There is no power given him for decision of the apportionment made.
Apportionment, if my lord test
Is wrong. Mm.
also mandates my lord.
Mm. Mm. The person to whom it is payable.
According to this provisions, which very that has been interpreted.
Where is that order?
It is in 1966. Act and the of 13.
But there are decisions of this court as well as the Supreme Court under section 76 and 64.
Yes, my lord. There's subsequently, my lord, in Sarada Devi, my lord.
Hmm.
2003.
Where is that?
TSCC.
No. After the 13 Act, there are decisions envisaging such position.
Any such of the Supreme
Yes,
Court.
yes, there is.
Bombay High Court has interpreted, my lord, taking well as the, my lord, the Sarada Devi case.
So you mean to say that the petitioner has to approach the collector?
Oh, he'll refer. He's mandatory.
He will have to refer. The money is yet to be disbursed.
First.
Already disbursed.
Was the civil court, my lord, he having the, my lord,
For recovery.
exactly, my lord.
The money has already been disbursed to you. This is by Junudas. Case is by you. Binita Das is the petitioner. And why is the notice? This is a suit filed by you, Mr. Huh? Why?
Is 40, my lord.
Page 40.
Is 40. In lessons.
This is a matter which has been referred directly. Or you have approached directly. No, it has not been referred. Just get the details. Mr. Sharma, you also get the details. What is this proceeding?
So, my lord, this also.
No. If there is a proceeding pending, we want to know what the proceeding is. And Mr. Sharma, what is the position on the law with regard to 64 and 76?
My lord, so far I am, the ADC has to refer the matter to the district judge.
But a dispute, but he cannot decide. Even in the 66 judgment that you have placed, 18(1) and 30, the decision cannot be made in the circumstances by the ADC. It has to be referred.
Yeah.
It can be. Okay.
Has to be made, otherwise, my lord, if there is any dispute in that.
It is not a matter of suo motu. It is he is bound to refer the
Refer it.
under 64 and 76.
Okay, when can you give me this instruction? Today? There are judgments I have come across. Let me see. I'll also be advised. Mr. Sharma, when it be convenient for you next week?
Any day, 4, 5.
4. Heard the parties at length. However, during the course of the hearing, Mr. P.J. Soikia, learned senior counsel appearing for the respondent, has submitted that, private respondent has submitted that a proceeding in the matter is already pending before the court of the learned additional district judge Jorhat. However, the exact nature of the proceedings is not known to him, and he submits that he would apprise this court on the next date of listing about the nature of the proceedings now stated to be pending before the said court. Full stop. Accordingly, registry to list this matter again on 4/9/2025 for 4/9, no problem. 9-9. Okay, 9-9-2025 for further hearing. In the meantime, I'll also try to ascertain. I'm just retaining this. Mr. Soma, if you can also throw some light.
Okay.
Yes, Mr. Bhuyan.
My lord, two affidavit has been, my lord, we have received, my lord. One by the, my lord, deputy commissioner and one by the forest, my lord.
What do you want to do?
Lord,
Here,
the rejoinder is required, my lord.
100%.
My lord.
The contentions goes to the root of the matter now.
Exactly, my lord. My lord,
Especially para 4 of the,
filed by the forest, my lord.
no, by the
By the
government
deputy
commissioner. If this is the correct position, your whole projection in the repetition is gone.
Lord, they have said, no, my lord.
You
just
come up
clarify
with your answer.
Exactly.
Come up with your answer. Because we will have to answer this.
Exactly.
And it has come on 19-8 only.
One difficulty is there. They have said that they have the notification exercise has been carried out under the Act, my lord, before the, my lord, reserving the land. But, my lord, in the affidavit, we have not found any such notification.
Okay, fine. You raise your objection on that. Mr. Bhattakur, the case of the petitioner is that they were in a particular chore. That chore was taken away by the river. And then it again emerged in the southern side. It was in the northern side, it came to the southern side. Now they are residing there, right? You had a particular defined boundary of that forest. Then came the first additional part, right? Now this first additional part, does it also bring within its area the chore now stated to be resided by the petitioners? Fine. But you have in your affidavit towards the later part said that you have carried out an eviction. And therein you have removed all the encroachers from your land now, even the first additional part. Now, whether they were also removed, if they were also evicted in that process. Because that is not very clear. Not very clear. Were you evicted or you are still there?
Not evicted from site A. Now we are residing in site B, my lord, temporarily.
No. There are cases you have approached this court. There are many things here.
Many things, my lord.
Now, after you came,
My lord.
when the land again re-emerged, and you said
that side we are not being evicted.
you are not evicted.
No, my lord.
Then you were evicted from where?
From the original place, my lord, wherein this notice, before this notice, my lord, where we were there, from that, my lord, Burasapuri, no? From Burasapuri, we have been evicted, my lord.
And now you are in?
My lord, it is nearby Burasapuri, but just 1 or 2 kilometers away. It is a tor area, my lord. Sometime it my lord, goes below the water.
So now you are not within the forest area.
Forest area, my lord. It is our country.
And what is your problem in this area now?
Because, my lord, the people, the forest official, my lord, still is now behind us, thrashing us that these are the forest land. So you cannot.
They have clarified that they are not trying to evict you.
My lord.
Rather, they are trying to prevent you from carrying out activities in the forest.
No, exactly, my lord. If that the area wherein we were originally there, my lord, before our eviction from that place A, my lord, if they have earmarked within boundary or that area bring under the notification as a reserve forest, my lord, then that is a different issue. But now, my lord, wherein we are residing at this place, my lord.
That is government land, khas land.
That is the stand of the government, my lord.
But the government says that there is no shore.
That is correct, my lord. In that affidavit, they have said, and I have taken instruction, my lord,
Hmm.
and I will come up with the record, my lord, whether this
Okay.
is sure or not.
And also, Mr. Bhuyan, you will have to bring on record
My lord,
what is that called Gorohonia certificate.
the land erosion certificate.
Ah.
Every person do not have, my lord.
Then you have to have that.
My lord.
You have to have that because you claim that you were having land in that earlier chore.
My lord. My lord.
If that be so, your connection is established.
That is correct, my lord, and we did approach from the year 1999, my lord. There were
I
two-
got it,
my lord.
but 1999 is inconsequential because before 1999, you were having, as per your own statements,
My lord.
somewhere else a route.
My lord.
Now establish that route because that admittedly you were displaced because of river erosion. And it's a admitted position if there is a person who has been affected by river erosion, he is given this certificate.
I'll try to bring it, my lord. I'll try to. but-
Right, Mr. Sharma?
My lord.
Now, we'll have to go into that angle also because only looking into the fact that 99 you have been a place B and you make some claims. But before 99, where were you? If you were really rendered landless,
My lord.
you had land, rendered landless, the thing would be different. And if you have come up in 99 without any route anyway,
My lord.
that will be different. Mr. A.R. Bhia, Learned Counsel for the petition, submits that affidavits on behalf of the respondent number 6 and respondent number 7 have been filed in the matter on 19/8/2025. Accordingly, he would accordingly he is under instructions to file rejoinders thereto on behalf of the petitioners. Also, he submits that he be granted a 3 weeks time to bring on record the rejoinders on behalf of the petitioners to the said affidavits. Prayer is not objected to by the Learned Counsel for the respondents. Also, accordingly, registry to list this matter again after 3 weeks on a date to be fixed by it. Full stop. The petitioner,
My lord.
you will not prejudice you now.
My lord.
You fight.
Some persons may have, some may not have also. My lord. Try.
If you don't have, there has to be a plausible explanation. Because this is a certificate which normally is there, with my experience.
Foreigner certain cases, my lord, lots of people annex this certificate. My lord. Oblige me.
That we do not take. That matter, my lord, briefly, my lord. The last,
Where are the reports?
the only thing, my lord, before my Ranefan begin, my lord, the last proposal, my lord, Lordship asked me a question, my lord, whether, but apart from the environmental problem, my lord, whether if building allowed to be established, whether affect the land or not affect the land. But there is a report of the agriculture department, my lord. They said that, my lord, if the pre-clean is allowed to function, they affect the land. That report, I will hear that repetition. Kindly see. And my
Okay, fine. We'll come to that.
Two point I'd like to clarify before your lordship, my lord. That is, two reports say that it affect the heat will go up, it will affect the. Second is this, my lord.
Mr. Borua, the effect issue here is that there are 2 reserve forests or wildlife sanctuaries, whatever it is.
Two parts, my lord. One is Gula Mayan and the other Raja Mayan.
So
My lord, this, my lord.
this will either be this will be within the economic eco-sensitive zone of either. That is what we want to clarify first.
I think, well, another lordship, give me the time, my lord, because, my lord, they Procedural Wildlife Sanctuary consists of 2 parts. One is, my lord, Procedural Wildlife, and second is Rajaman Wildlife. And this, my lord, briefly is situated in which of these 2.
That is what I'm saying. That this will be either of A, eco-sensitive zone, or of B, eco-sensitive zone.
Yes, yes.
It will be either, or it will be both.
Learned friend, my lord, said, my lord, it is, my lord, 1200 meters from the outside side of the fact, my lord, it is, my lord, which of the, my lord, these 2 parts, it is a speaking for it is going to declare, my lord, that equation slip.
We'll say, yes.
But then 3 days are last day.
See, there were 2 reports basing on which the deputy commissioner has passed the order. I want those 2 reports, which is given by your officer. Wait. Yes, Mr. Soma, what is your stand?
On the order passed by the deputy commissioner. That deputy commissioner passed that order on the basis of the report submitted by the forest department.
Where is that report? Where is that report of the forest department? There are 2 by the Nagaon Divisional Forest Officer and Morrigaon Divisional Forest Officer. (1912) order. Where is this 1912 order, Mr. Burwa? So this is the impugned order. Okay, Mr. Bhattakur, your instruction is that although the eco-sensitive zone is yet to be determined, however, a default eco-sensitive zone of 10 kilometers is already in place. And this kiln of Mr. Bora will be within that.
On that same count, lot close. Thereafter, we have the Honorable High Court challenging that order. Now, Honorable High Court passed an order on 38, 2023. But you could find it at page 151. I'd like to place that for
151.
that covers 50 also 151. Now, Lordship will firstly come to page 149, the impugned order. For a moment, para 4.
This is what is now being reiterated by.
The impugned order.
Okay, fine. 10 kilometers, yours come within 10 kilometers. So then what happened?
At page 151 was the order. At 153 it starts.
Where is the relevant portion?
Yes, relevant portion. To find that at page 155 it starts. I have heard Lordship. Now at 156, Honorable High Court quotes the order of 2018. Now 158, Lordship would see a perusal of the above quoted order.
158.
158. A perusal of the above quoted order would show that the proposal for 21 National Park Wildlife Sanctuary was yet to be received by the Ministry and the Forest, among others. The Supreme Court categorically directed in the said order that an area of 10 kilometers around the 21 National Park and Wildlife Sanctuary includes Provincial National Park to be declared eco-sensitive zone. The said declaration was to be made by the Ministry of Environment and Forest at the earliest. Therefore, from the order dated so and so, the Supreme Court did not declare an area of 10 kilometers around the wildlife sanctuary as eco-sensitive. Rather, direction was issued to the Ministry of Environment and Forest to make declaration at the earliest. On the other hand, if the court takes into account the impugned order dated 2/3/2019, the Deputy Commissioner Morrigaon has revoked the no objection certificate on an assumption that the land of the petitioner was located in the eco-sensitive zone. This aspect, in my opinion, this court was based on an incorrect assumption of the order passed by the Supreme Court at 11/12/2018. He did at me. What that is the finding of this.
Just a minute.
Fine also, Lordship.
Give me 2 minutes. So the order was interfered with and matter was remanded to the Deputy Commissioner. This court clarified that the Supreme Court, there is no declaration. Further, the government of India had not made that declaration. And there was no move from their end also to make that declaration. Then,
Last occasion, I showed a judgment of 2023.
then 162, on the basis of that, the NOC was reinstated.
Reinstated, Lordship.
Okay. Then again,
Thereafter, again, Lordship,
case was filed.
the same petitioner filed a case at 164. The order.
Now let us see what is the conclusion of the court here. Have you seen? Mr. Borua?
Yes.
Yes. What is your, let us take it point wise. What is your first objection?
Regarding 10 kilometer, my lord.
No. Regarding establishment of this Brooklyn and the impugned order.
Yes, my lord, my imperial is my lord, that the imperial has not stated anything about what will affect if he going to be.
Effect
that order, my lord, has
of the Brooklyn.
that, my lord.
Brooklyn on what? On what? Effect on the environment, land.
Adjacent land of the petitioners, my lord.
Okay. Second ground.
Second one will be, my lord, the order, my lord, is earlier
heard by the my lord EDC and has been passed by the my lord Deputy Commissioner, Deputy District Commissioner. Now they have not filed any fee for this allegation, my lord.
Okay, fine. We'll take it that it is admitted. Then next.
Next in my lord, the Supreme Court judgment of the my lord that ecocentric zone 10 kilometer radius will be
Okay, that issue was gone into by this court in the earlier round of litigation.
that kindly see my lord the operative part that may be seen my lord 161 my lord
Page?
page 161. Operative part start from page
160, para 12.
yes my lord. According to the instant writ petition, therefore stand disposed of with the following observation direction. The order dated 2/3/19 passed by the Deputy Commissioner Morigaon, by which the no petitioner dated so was revoked, is set aside and quashed. The Deputy Commissioner Morigaon is directed to decide afresh within a period of 8 weeks from today as regards the no objection certificate so issued in favor of the petitioner after considering reports of the stakeholder and giving opportunity to the hearing of the petitioner as well as the private respondent hearing, and also taking into account the order dated 23/11/2017 passed by division bench of this court in WN number so and so. The Department of Forest Environment of Government as well as the private respondent are permitted to bring the notice of the Deputy Commissioner Morigaon any further development in respect of Pavitra Wildlife Sanctuary, and more particularly to the order dated 26/4/2020 passed by the Supreme Court.
Okay, fine.
That is.
Then an order was passed.
That court has not said that did order go by, my lord.
Fine.
Taking into consideration that
Fine.
particular order.
Then the Deputy Commissioner passes an order dated 19/2/2024, page 162, which is again put to challenge before this court
Yes.
in 19/4/2024.
Yes.
Now you come to 1942. The court notices everything.
Yes, my lord. That is the order, my lord. Kindly see. 173, my lord. Start from 173. There's authority. But taking the above, this court disposed instant petition with following observation or direction. The
Forget it. Come to para 10.
my lord.
Para 10 is the conclusion.
Yes. There is no reference report submitted appraised by Pollution Control Board as well as Agriculture Department officers. Under such circumstances, opinion of the court, the impugn order dated 19/2000 is contrary to the specific direction passed by the Rana Division Bench of this court by order dated 23/11/2000 in WN as well as the direction passed by the court paragraph 12 of Roman 2 of the judgment of the order dated passed in 2000. This impugn order
So, para 13, the direction is that the Pollution Control Board will submit a fresh report. District Agriculture Officer is also directed to submit a fresh report. DFOs having already brought their stand on record, no further order is required to be passed, no further this is. And now the Green Tribe NGT also said, let the Deputy Commissioner take a call in the matter.
Yeah, the committee has been formed by the NGT, my lord. They're compromising the
No, there is a direction specific to the respondent here that it should be done by the Deputy Commissioner in terms of the directions passed by this court.
That is what what is the direction?
Now tell me, what is the error in this page 187?
Trustee, kindly see, my lord.
You can skip till the penultimate paragraph of page 187. It's just
188. Turn to page 188, my lord.
yes.
Second paragraph from the and whereas as per the report of the Pollution Control Board Assam by letter dated so and so, consent to operate may be given to the BBA brick after completion of conversion of zigzag technology brick and subject to all requisite pollution control measure as per consent to operate Pollution Control Board Assam. And whereas, as per a report of the district agriculture officer, Morigaon filed letter so the land where the safeguarding is situated is not suitable for the major agricultural practice. But where is the one stated regarding the effect of the land? The report. The agriculture report has not said, they only said, my lord, it is not suitable for major cultivation. If, my lord, this brickling ought to be less,
You show me the material that the brickling operation would affect your land. What is the material?
Very fast, I said, my lord, kindly turn to, my lord, page 50. Page 50. The earlier report of the agriculture.
50.
Yes, 50. Before filing the first litigation, my lord, that is page 50. That is a report on 2012. Kindly turn to probable after effect.
Page 50.
Page 50. Probable after effect. After setting out the brick industry, the productivity of the Bodupedi of the adjacent pole plot will significantly drop down. Temperature of the surrounding area will increase and result of the crop may be affected. Pollution surrounding area will create health hazard. Emission to smoke containing carbon may often settle down to the soil, as result of which CNO ratio increases and may affect the crop yield as well as soil health. That is the first report of the Milo agriculture officer.
And where is this report of the agriculture officer which is relied upon by the deputy commissioner in the impugned order? Is it on record?
Yeah, it is the first report.
This, whereas perusal of the page 1.
Again, my lord, after the first litigation, my lord, another
Page 188, third paragraph, 22/10/2024.
Yes, my lord.
Where is this report? Is it on record?
No, it is not in the record.
You have that? Okay. Okay, Mr. Barua, what is the material on record to show that in the adjacent land or to the brickling, you are carrying out agriculture activities? Where?
A specific,
Where? Just show me.
paragraph 4, my lord, of the petition.
Paragraph 4.
Other people have cultivated land in village Sangmax Kisam under the Mayang Moza in around the proposed brick lane of the Rational 11. And thus, as a cultivated land, there is a declared sanctuary which is known as wildlife sanctuary. If any interest is allowed to establish the said area, it will cause serious problem not only the health, but the animal life of the high citizen. Moreover, it will affect the surrounding.
Yes, Mr. Borua. Your report that was considered by the Deputy Commissioner is to the effect that the establishment of the bricklet will not have any major effect on human because habitation is far away. But why have you not taken into effect the locality, the adjoining plots, agriculture? Because the agriculture officer says that this particular plot is not fit for agriculture. There is no report that the other plots are not fit for agriculture. This report does not take into consideration that.
In fact, we are only concentrating on the aspect of pollution.
Pollution.
As regards the,
Pollution and the effect.
the circle of reports of all last annexure of this. Clearly state
That is gone now.
that apart the others.
Now, page, that report, if you have it. It says it may be commented that there is not any apprehension of environmental hazard and health hazard from this unit. At the time of recent visit of the officials of the board, it was found that there was no human habitation. Schools, hospitals, worship places nearby so and so. As per record available with this board, the near human habitation is so and so away from the bricklet. No dispute on that. But if there is agriculture land surrounding that bricklet, what would be the effect on those agricultural activities being carried out therein? That has not been enumerated here. And they are operating. You're operating it now. Huh? You're operating it now.
Now it is the turn of
Documents which I'll show in.
Yes, Mr. Burwa. What is your latest report or your projection that the operation of this has caused effect to your production, effect to your land? Environmental thing gone, because that eco-sensitive thing is not done. This court has done away with it. And with regard to that observation, no appeal was preferred. So it is only with regard whether the land, operation of the land or utilization of the land for a bricklaying is affecting your agriculture produce.
My lord, because the report of
That show me.
the report
That is gone now. That the report is now taken care of in the subsequent proceedings.
not been taken. What manner agricultural department report has said. Earlier, can I say contrary to
No,
the
where
other
is that
report-
latest thing that that report, Mr. Borua,
Yes, sir.
that report was before the operation of the bricklet, right?
Yes, my lord.
Huh?
After my lord, before that is a court for ask for a report, well, is going to establish what will affect. They say here, give me the report. Now, my lord, Loxic asks for a report from the agriculture department. They have only say, my lord, that they no major cultivation. Whether agriculture department have.
That's what I'm saying. What is the major cultivation? What is the proof that you have been carrying out cultivating activities other than that statement?
I'm acting, I'm making a statement, my lord. Even issue a commission, my lord. I'm making a statement on oath, my lord. And if I'm making a wrong statement, I'll held up for perjury, my lord. I make a statement, my lord. Can you see? A categorical statement made since 2012, my lord. Not for fun, I come before your lordship, my lord. We the poor people, we are suffering cultivation land. Our main concern is.
Who is for the agriculture department?
Well, I am fighting, my lord.
Agriculture department is a party here. Mr. Borwa, agriculture department is a party here.
Yes, yes, my lord.
Respondent number?
Question of 5, my lord.
5.
5, my lord. District Health Officer, Morigaon, Assam.
Who is representing District Agriculture Officer Morigaon?
Council is there, my lord.
I was appearing on the.
Can you get hold of her? Okay, Mr. Borwa, now the only thing that is to be seen whether the operation of the kiln, which is now taking place, has caused any adverse impact on the agriculture activities. That much only. The rest have been taken care of.
Another thing, my lord, Orsim kindly, if that dustbin will also go.
And we'll also provide that tomorrow, if the eco-sensitive zone is brought into operation and it covers the kiln, and the consequential actions which as may be mandated under law will be taken.
Permit, my lord. What about that division bench judgment, the 2017 judgment? That is only referred in that two judgment of this court, my lord, earlier two judgment, that whether it going to establish whether it affect the exertion or not. That has not been taken.
That is what we are doing now.
Against that, they have not filed any.
Now, that is what we are trying to do. We'll
Yes,
get hold of the standing council and then get a report and then see what happens.
And my lord, this pollution control board.
Mr. Borwa, the report will be prepared after site verification involving the petitioners as well as the respondent number 11.
Yes, yes, right.
Then we'll take it up and we'll proceed further.
Yes,
Can you just wait? Can you get the standing council agriculture department for that? Whoever is the standing council? Huh.
Only thing, my lord, see, only hurting, my lord. My lord, we are really suffering.
Let me understand that if the report comes that it is, we'll close it down. There is no problem. We'll close it down. But now the order has been passed after scrutiny by this court in different cases. Let us get this issue resolved. Let us get a report. Fine.
Nothing, my lord.
What is your take on the agricultural activities in and around?
Yes, Lordship. 4. Very vague statement.
Forget it. There is a statement. What is your take on that? Whether agriculture activities are going on?
In 2012, after my brick kiln was established on 2/3/2011, they had come to the court. In 2000.
I'm not on that. Today, after your operations have started, whether the operation of the brick kiln has in any manner affected the agricultural activity.
That instruction I'll also take, Lordship.
And whether any agricultural activities was in fact being done there.
In fact, being done, and no statement, Lordship. At least what agricultural.
This is a writ petition. Let's not be so technical. If there is an effect, we will come in. If there is nothing, we'll hold that he is a busybody. But Mr. Borwa has brought at least some allegation. Now that's the only area which we have to examine.
Page 55 of the last 4604, that is already here. And page 116, there are RTI reports that 7 other brick kilns are there. 7, they are not affected by it. Secondly, in the last proceeding, the Forest Department has placed an affidavit at page 241, which says that 10 brick kilns are running. He is not affected by it.
10 brick kilns at what distance from the plot of the petitioner?
Page 55 and 116 distance are also given.
From the?
4604, the records are here, Lord.
Page 55.
No, of 4604. 4604 petition.
Page?
55, as far as I remember, and 116.
No, this is far away. Not near the land of the petitioner. This is admittedly 2.5 kilometer, 5 kilometer. What I'm on is that whether the adjacent lands have been affected.
Lordship, I'll also take instruction.
And what is the next page you said? 155?
116, 40, 240, 241.
$200?
44, as far as I remember, Lordship.
Okay, fine. Till now, your remembrance is okay. Adjacent means adjacent to the property of the petitioner or that area.
There is no pleading that he has a property.
Oh, Mr. This is, we are considering it under 22-6. So let us also have that satisfaction. Get hold of the standing council agriculture. After some time. Just inform her if any issue is here. Mr. Borua, we'll get a report, then we'll proceed. Today, let's see how long she will take to give us that report. Whenever it's convenient to you, we'll not list it on a date inconvenient to you. That much I can assure you.
Your Lordship.
Let us get that report.
That is, my Lord, what radius. That is the interest rate. That is the reason, my Lord.
Mr. Borua, those issues have been already gone into. Now, the only thing that we have to look into is
Lordship, subject to correction. I very apologize to Lordship, my the judgment of the
unfortunately, the matter was dealt with by.
141 is
I'm sorry, that order of the coordinate bench is binding on me.
141, my Lord. The lateral bench will prevail, my Lord.
But I'll make a provision that if there is a declaration of a eco-sensitive zone, the consequences will follow. Why is the declaration not being made? Okay, the Supreme Court gave you the authorities a liberty to declare 10-kilometer radius as an eco-sensitive zone. Why a notification in that connection is also not published by the... Okay, fine. But you have a boundary which is not disputed. From there, 10 kilometers could have been done. That would have been in interest of all. Why it has not been done? Have your instructions on that also.
Well, if I come here, well, my
No, please, your junior will do. I've heard you.
got injured in my case, particularly dangerous.
You,
Yes, my Lord.
please go and take rest. And tell him when it will be convenient for you, a date. I'll fix the matter on that date. Yes, Mr. Rabba, your matter. Yes.
My lord, in fact, stay was taken earlier, my lord.
Earlier?
Did not return, my lord.
But when was it
Later,
taken?
my lord, it was listed before Lozima Court.
Lauzima Court is passing orders right from March, even before that.
I acknowledge the mistake.
And your friend,
And
because you were not here, we did not dismiss the matter.
My lord.
But thereafter also you have not taken steps.
My lord, I was abroad, my lord. So that's all. Kindly allow me at least one day time to take fresh step, my lord.
Where is that impugned order?
No, what is that? Is page 24, my lord.
What is your stand, Mr. Hmm. Now, this is again with regard to that issue in a case where Mr. R. Sharma was appearing. When was your jurisdiction extended to? This was under a Gaon Panchayat. When was it your jurisdiction extended to that? When was this house constructed, Mr. Rabha? 2001.
2001, my lord.
So 2001, whether the GMD Act was, GMD authority was extended to that area. I know that. I know, but
Is the
whether this village is also included there. Your village is
Kahikusi.
Kahikusi.
It is under Kahikusi Gaon Panchayat.
item number 3 of my affidavit.
September 1986. Yes, Mr. Rabha.
My lord, at that
You have
point
not
of-
admittedly taken permission because that coverage is there from 86.
At that point of time, my lord, it was under the
Maybe, but the act had come into being and the area was covered. And you knew about this from 2019. You have not cared to file even a affidavit against this. Para 3 is not controverted by you. And notices under section 88 was issued. You received that.
I have also replied to this.
There is a provision. 71 of the June.
But that was also not done. Now, admittedly, this house was constructed without the permission under law.
Under petition, my lord,
And who is respondent number 4?
Gaon Panchayat, my lord.
Or we ignored the Gaon Panchayat.
I think,
We
my
ignored
lord,
the Gaon Panchayat.
Gaon Panchayat needs to be heard, my lord.
No, no, we ignore him.
Their stand has to be.
You establish that there is a provision of law which says that the Act, Guwahati Municipal Metropolitan Development Authority Act, extends to Kahikuchi from 86. Somebody has given you a permission, that will not give it you a right. And this affidavit is there from 2019. You have not filed a reply to this. Is it compoundable? Because maybe on a wrong notion of the matter, he had taken a permission, and a governmental authority giving a permission, it's also possible that he had, and we have found many cases of this nature, he had made it. So if he approaches you, whether this can be regularized. Kahikuchi, what is there? There is when was it declared? When was the eco-sensitive zone declared? If it is after 2001, then that will not be applicable to his. Can you have that instructions? It's very easy to hold that he is constructed, but no, for that we'll have to have we don't want to issue a futile writ. You get your instructions that whether this is permissible to be regularized. Then we'll pass a direction. So, Rabba?
Took 18 years to, my lord.
Oh, they did not know. Now they are coming to know.
At that point of time,
Heard Mr. S.R. Rabba, learned counsel for the petitioner. Also heard Mr. S. Bora, learned counsel representing the respondent number 2. Mr. Bora shall receive instructions as to whether the building constructed by the petitioner, basing on a NOC issued by the by the Kahikuchi Gaon Panchayat in the year 2001, without a prior approval from the GMDA authorities, can now be regularized. Full stop. The said this court be Mr. Bora to receive the said instructions and apprise this court of the same on the next date of listing. Full stop. Petitioner to take steps for service of notice upon respondent number 4 by way of Dasti mode within 2 working days from today, and thereafter file an affidavit to envisaging service of notice upon the respondent number 4 by way of Dasti mode routed through the registry of this court. Full stop. Registry to list this matters again on when? On 17 September, 17/9/2025.
meantime, my lord, may I file also a reply affidavit?
That's I'm not touching it. That's up to you. Interim order passed earlier to continue till the next date of listing.
Your Lordship,
Yes, Mr.
my lord,
Good.
I have gone through, my lord. Your Lordship may kindly come to page 21 first. Quotation paper. May I read your Lordship? Introduction. The undersigned, on behalf of the government of Assam, intend to
procure certain tools and equipment for different industrial training institutes of Assam and invite
I've got it. There is nothing with regard to commissioning there.
commissioning.
Now come to
payment
page.
I will come, my lord.
Hmm.
Uh,
Payment is also looked into, Mr.
as per
Goel,
supply only after
on supply. But you come to page.
I am coming, your lordship.
Hmm.
When it was in good condition.
Hmm.
So accordingly, they have made payment, entire payment. My lord.
Hmm.
So after they found that goods are in good condition, now my lord may kindly come to page 34,
Hmm.
supply order.
Hmm.
Subject,
Hmm.
supply of tools and equipments to ITIs under enhancing of skill development infrastructure in any states and Sikkim. So subject is supply only. There is not a single whisper about commissioning.
Hmm. But special instructions.
That is
Hmm.
special instruction.
Hmm.
The supplier will remain responsible. I will be responsible, my lord, until the entire goods and equipments reach in good condition. It was reached in good condition. That's why they have made payment, your lordship. And after successful commissioning of the goods at destination, it doesn't say, my lord, commissioning has to be done by supplier. My duty was, as per quotation, it was only for supply. Because of that, my lord, they have made entire payment on supply of goods in good condition. So the commissioning part is there, it lies on them, your lordship. They will commission their own. If something is there, for that I am responsible.
Yes, Mr.
This
Das.
is my.
That's the case. Why? He's before me. Why should I send him to the authority? You tell me. What is this? Whether he is required to commission. Where? No, I'm not on your letter. I'm on the requirement. There is no requirement in your quotation. Here also, after successful commission of the goods at destination. This is with the further stipulation that he will be paid the money only on supply being effected in good condition. And see, you have released him his pay. Luckily, no. Today we can't say luckily. See, it should be very strict. That condition which he will not fulfill has to be a condition which has been projected to him with a requirement that he will have to fulfill it. Where do I find that? This is not the condition. It does not. Okay. Now we come back. This is with regard to B and C. So thank you. I missed out on that. B and C is with regard to payment of money. And E is with regard to earnest money. Now read again. So here he has made the supplies within the date. No, you have been released the full payment. Where? Okay, 73. Let us see.
Commissioning report.
So commissioning report is from the consignee. Consignee means you, yourself. So he is not to be, so where is that? You should not have released him the money itself. No, whether you have drawn up proceedings against persons who were involved. Why? Why? Why should the petitioner now be put to trouble? Where is his requirement? The commissioning is by you. Somebody writing will not do. Where? that initial tender, there is not even a whisper, Mr. Das. There is not even a whisper. I was trying to find out even a line somewhere. It's only supply.
Not again.
Ah. So where is the requirement of he making the commissioning? Hmm. Just a moment. Okay, got it. Page. Hmm.
With respect to the above, I am to inform you. Okay.
No receipt, my lord.
Representative.
First time it has come
Sure,
to.
official.
Official letter, that's why.
First been annexed, but I
There is no receipt, my lord. We never received.
How can the man give back a material which has been supplied to him without taking an acknowledgement? And this matter came up, the supplies way of 2013, 11, 12, 13. No, dispute should be in substance, not in form. Now, come to your affidavit. Para 5. There are two things here. One is 9.2 special condition and the letter dated 1/12/2012. Now you come to the letter dated 1/12/2012.
have standing.
So this is a letter of 1/12/2012, right? Now, your para 5 has been replied to him by para 4. Where is your reply to this paragraph, Mr. Goel?
My later. For your lordship.
Where is the document to envisage that this letter was served on her? 1/12/2012. Get it? And what is the cost of the, where is that page 84? Wherein you have said that the materials were received. 84. Multimedia. No, that is it. Mr. Goel, which is the one here, which has been purportedly returned to you?
We have not received, in fact, page 83
This,
they are
that
saying.
material that was served, was supplied. It is here. What is that name?
Material.
Ah,
Our list is there.
no, what is
That
that?
I-
Multimedia something.
Page 86 you have also.
86.
Received by them. Receipt is there.
Which is the one?
Page 86,
Multimedia projector.
multimedia projector.
What is the cost of that?
Cost is not there. The middle your lordship received
The cost is somewhere. You will get it. That supply orders, along with that, the rate is also there. Where do I get this? Multimedia. And Mr. Das, these are all standalone items. Where is the requirement of a commissioning of these items? He has given you a computer, it's all configured.
55,000.
11 point?
55,000. Page 37.
55,000, page 37.
37. Serial number 20.
Okay. Now show me that this letter what is to be commissioned when there is nothing to be commissioned? This is, no. He has given you inkjet refills. He has given you a computer full anti-static mat for the table. You'll have to go and put it there. That will be used by you whenever it is required. This is anti-static mat. You require a technical person. Anti-static mat is that you put where above which you put your computer, laptop. It will not move. Now you show me that this letter of 2012 was served on the petition. Then we will take a call. 55,000, substantial amount, 1 lakh is only pending. We'll take a call. Tomorrow. Get your instructions. Tuesday.
Tuesday, not Tuesday, Monday or Wednesday.
Wednesday. Heard Mr. A. Goel, learned counsel for the petitioner. Also heard Mr. SP Das, learned standing counsel, labor and unemployment. Mr. Das submits that he would, on the next date of listing, he would on the next date of listing apprise this court as to whether the communication dated 1/12/2012 issued by the authorities of ITI Jorhat was in fact served upon the petitioner herein. Proceeding corner was in fact served upon the petitioner herein. Full stop. Prayer accepted, raised to list this matter again on 10, or we'll have it on 15th, 15/9/2025. You get your complete instructions. Sufficient time.
Deeply obliged.
Yes, Mr. Nath.
My lord, my learned friend is. Actually, very small issue. Got loan of.
They had sanctioned a loan, but they had not disbursed that amount to you.
They gave 1 crore. 7 crore they did not give. So we made a prayer. Since we have not given us 7 crores, the upfront money, the processing fees, which they have taken 8,82,000, the proportionate amount to give us back, they took the plea in the affidavit. No, you did not renew this one. That's why the amount was converted to WCL. That one they've converted.
WCL means?
Working capital demand loan, WC term loan. They've converted this one. So when we asked them that why it was done, they said no, because you did not renew this one. Now we have filed the affidavit and we give them their own paper. They gave us the document saying this is the date, within such and such date you renew. Within the specified period, we have given our applications for renewal, and thereafter nothing was heard. That is the case.
So 8 crore loan
Loan.
into something, it comes to a processing fee.
Processing fee comes to 8,82,000.
82,000.
That's right.
So you were given one crore.
1 crore. So rest the
Why the rest amount was not cleared at that point of time, released?
My lord, they have converted this one to 1 crore, some reason. And they did 1 crore, and they, after 1 crore, they converted to that loan, that WC demand loan. The repayment structure is a little different, shorter period. That is they have made. So you ask them that.
You got only 1 crore.
1 crore, yes.
And then they say that you have not renewed your
That
prayer.
is the reason, yes. And we said that you gave us a document asking us within such and such period.
Where is that document?
That document, my lord, lordship kindly see, that's in page number 54. 54. There's my additional affidavit. Filed on 27/4/23. By the way, my lord, one thing. Lordship has seen any picture in Kelvin Cinema Hall when Lordship was here, my lord?
Olden days.
Yes, it is that cinema hall was, my lord. There it was broken. And then the
Okay,
building was
Kelvin
constructed
Cinema
here.
Complex.
Yes,
Okay,
yes,
okay.
yes, yes.
So
Now
it's
it's
a
become-
landmark.
That's why I say, Lordship might have seen picture there in that hall.
My father used to tell me that Dilip Kumar pictures were regularly being screened there.
There's a very famous picture in those days. So kindly see page 54. That's dated 7th December 2010. CC limit of 1 lakh sanction to you is due for renewal and will be expiring on January 26/11.
It was a credit limit given.
Yes, CC limit, credit limit, yes. So kindly see the next page, page 55. 7/1/20. Request for renewal. A reference, your letter dated 7/10, 7/12/10, the earlier one. So we have submitted these documents. It is on their part.
Yes,
now.
Mr.
This is the issue basically, my lord.
Mr. Doctor. This is a cash credit loan. So the limit is there. They can go up to 8 crores. So for 8 crores crash credit limit, you have taken a processing fee, what I have understood, which is around 8 lakhs. And that is proportionate to the amount which is being sanctioned to him. You have a formula maybe. Now he has taken only 1 crore. So the balance remains. And maybe on the year he could not take it.
My lord, not I have taken.
No, well,
No,
They have given.
it's slightly different. I'll let you let you finish.
no, give me the correct picture.
Yes.
Limit is sanction.
He can avail it, he cannot avail it. Mm.
Now, thereafter, we determine
Mm. Mm. Mm.
made by law.
Mm. Mm.
The note to us that accordingly, my lord, there will not requirement.
You are ready to give 8 crores drawing limit, but the drawing limit has to be year to year fixed. So that was okay. It's not a loan, it's a credit limit given.
Generally, 12 months
Hmm.
or
Hmm.
they could, my lord,
Hmm. Hmm.
out of that, they could subsequently, my lord, when
Hmm. Renewal the next year.
Yeah.
Okay.
had this limit of 8,
Hmm.
they could not only have a draw. That too also they could not utilize.
They went for 1 crore there.
When in fact, the loan was closed also by them. They said that we are getting a
This is what this is not exactly a loan when it is sanctioned. The money is there. Without his money being in his account, he can issue checks to that limit. And that will be now becoming, once it is issued, becomes a loan. So then he'll have to repay that. Hmm.
what happens, my lord? Lesser. Anyway, the drawing power may be higher than the limit also. Drawing power is lesser. First year,
It's like a credit card given to him. Hmm.
drawing power of 2 crores. Accordingly, my lord, he was
Now, why, then if he has utilized 1 crore, why this processing fee for 8 crores was taken?
this is because actually he has. Then, my lord, we found his limit. My lord.
So when you are allowing a person a limit,
Limit.
now do you not consider at that point of time whether he has the resources to go to that limit? No. At that date, when you gave him 8 crores, you did not know that he would be able with his securities to go for 2 crores only. No. On the day when you said 8 crores limit you gave him, that means you were satisfied that he could achieve 8 crores. But now that you say that no, he did not have the the resources or wherewithal to have 8 crores, he had only 2 crores.
After the loan was sanctioned.
No, how did you sanction this 8 crores when he did not have the...
These are the
All
projections.
security land documents, everything is given.
These are all projections, my lord.
And the security that he's been given.
Writ petition.
Now come to page 12. Now come to page 12 of the writ petition. So 8 crores, you were satisfied that he can be given 8 crores, right? On that, you said 1% of the sanctioned amount plus, which is 882,400, 8 lakhs. And margin is 25% of stock and book debit. That you forget it. Then he gives you a hypothetication of the movable assets.
Page 18. Page 18. Page 18 and 20. Page 20 is very specifically stated. 8 lakhs, 800 lakhs, 8 crore. First paragraph, last line.
Page
20, 20, Annexure 3. First paragraph, last but one line. First paragraph.
So 8 crores, that was sanctioned credit limit. He has secured it with property. So you are safe with 8 crores. Now, where is that letter of his that he cannot avail the full amount? He'll only avail. Page 22 is not that letter. It's something else. How did you come to that drawing limit calculation? It is there in your affidavit.
Is there, madam? We have stated this.
Just take me to that. Where are you reading? 42 para?
Guidelines for charges, Lordship, particular.
Nine, 10, what is the internal page? Okay.
Guidelines for charges.
The processing charges upfront. When a party approaches the bank for credit facility, processing upfront fee should be charged by way of a lump sum amount at the time of initial processing as far as possible. In all types of cases, term loan, non-fund based facility, project loan, corporate loan.
No.
No, just show me that although he had approached this 8 crore thing, that was on his approach. Later, he wanted a lower, the drawing limit to be fixed, not at the limit of the. No, where do I find that? No, your affidavit. So you restricted it on 18/3/2011. How?
But the statements made by 1/10/2009. Was not resorted.
Then.
Then, my lord, paragraph 9, the
So he drew 1 crore, but that 1 crore was not repaid within the 1 year. So you converted it into a working capital demand loan, term loan, and the interest in one of your annexures, I find it is around 2 lakhs. So after the conclusion of the first year, it was 1 crore plus 2 lakhs. Now, where do I get this restriction that you have placed? 18/3/2011. And after the loan was sanctioned, credit limit was given on 21/10/2009.
it should be 10. 9.
It- 9.
It should be, no, I think it should be correct. Should be 20, 10, 10. It should be.
No, it is sanctioned on 9. Released on 11/5/2010. Between October 2009 and May 2010, is there any letter from the petitioner requiring you to reduce that? Where is that? You have not said so in the affidavit.
My lord, how can it be 9? Because kindly see,
Hmm.
Sanction on 21/10/09.
Hmm.
21/09 and will expire on 20/10/09.
No, that is a mistake. That second one would be,
Should be 10.
that will be 10.
Yes, yes. So 10 is.
Just. See, the only thing I have to ascertain here is that you were ready, he did not.
Flag, my lord.
No, it's okay.
Flag B, my lord.
Sanction, it is there.
What is this upfront contribution from 75 to 25? Means their investment in the project? No, it is an investment in the project. Conditions would be there in that sanction letter.
Uh, 14, my lord. Sorry.
Serial number 2. What is the intention of this paragraph? Raise and deploy of at least 75% of the envisaged cash contribution of so-and-so lakh by the promoters. In the project, that means. Then what happened? Where is the first letter written by him for refund of the excess due?
It's in page number 27, Annex 7 of my
Seven.
report.
After the loan was.
Yes, Mr. Nutt.
My lord. This is a business between the bank and its customer. A lot of things happens, discussion, many things happens. My submission will be, when the business was going on, the discussion is going on, they've considered everything is because of this reason in page number 54, look once again, page 54.
Hmm.
Worship is seen. See that's letter dated 7th December 2010. What they've written here? CC limit 800 lakh sanction to use due for renewal and will be expiring on 26 January 2011. To enable us to renew the facility, kindly submit the following documents. So the specifically states here 800 lakhs. See the next page. That was on 7th of December. And on the same day, kindly see 7th of January 11. Reference your letter dated 7/12.
You have given.
Request for renewal. So knowing fully well about the business between these, my lords.
No, Mr. Nath, there is another aspect here. This is a situation wherein you have approached the bank. And in the project report that you had submitted, you had projected that you require a cash credit limit of 800 crores. Right? That was agreed upon. And they also agreed that we will give you 800 crores basing on your projection. Thereafter, in terms of the policy holding the field, you have to give a upfront processing fee. You gave 8 lakhs. There is a letter of yours. You gave 8 lakhs. But therein you required that your share, you are a promoter, your share be reduced from 75 to 25. Then the authorities reverted back, saying that that cannot be done. So that thereafter, because your share in that whole thing having not been there for 75%, they said you can draw 200 crores, 2 crores. 2 crores. But you did not have the wherewithal to draw even 1 crore. You could draw maximum 1 crore, which you again did not repay within that 1 year. It became a loan, term loan, and 2 lakhs was added to that. So in this view, that now that you have gone to them and the loan was sanctioned, but it is your fault that you could not draw that amount. So the upfront processing fee, how can it be returned?
If that is so,
And you have made this plea before them only after the loan was closed. Everything was done with. You had never asked them that now that you have not given me it full, keep the proportionate thing, 200 proportionate, give me 600 proportionate back.
does the record, I don't have the access to the records. Does the record say?
Mr.
It's all done, mine, it's all right.
No.
No,
Why?
it's all right, it's all right.
This is not a national secret document here.
No, it's all right. Once Lordship is satisfied, I don't.
No, I'm not satisfied. Mr. Nath, please don't. What I found, I just
Yes,
put
yes,
it to you.
yes,
I
yes.
want your response
Yes,
to that.
yes, sir. I feel, my lord, when they have converted this to 100,
They have not converted this. They have
CCL limit.
No, they have kept the CC limit at 800 only. But your drawing limit was made 100 because of the discussion with you. They were ready to give you 800.
That reflects there, my lord. According to that.
That's why.
It's all right. It's all right. It's
Oh, Mr. Nath.
my lord, I'm not going to see, my lord. I'm not going to see, my lord. No,
No, you
I'm
have
not
to.
going see. I
This is a court order.
trust, my lord.
This is
trust,
a
my
court
lord.
order. This is a court order. Mr. Nath. Mr. Doctor.
No, I accepted, my lord.
No. You go through it in the break. We'll come back in the second half. No. Go come back in the second half. Be satisfied. You have to. No, you'll have to. The only question is whether they had reduced the 800 limit to 100. I do not find that. Only your drawing power was, because if you had the wherewithal, you could have gone up to 8 crores. If that be so, this is only processing fee.
Just if it is like that, my lord.
This is for
Yes,
court's
yes.
assistance. We are given you. The records, Mr. Nath or Mr. Bora will go through it.
This is
Kindly.
my lord, definitely. But what's the meaning of this letter then, my page 54?
What is that?
That
renewal. We are not going for the renewal thing. We'll not go for the renewal thing. That point is wrong. You had given it, but thereafter they closed it. So if it is not renewed, but the issue remains that 1 crore that you had utilized, it did not remain as a cash credit because you did not. It was again made a loan, which you subsequently closed from somewhere.
The record shows that, my lord, obviously, my lord.
No. When? Today or tomorrow? Whenever you want it. Today? 2 o'clock, second half?
Tomorrow.
No. Today, second half. Whenever you are ready, just inform. There will be 2, 3 matters before that. Thereafter, we'll take that. These are new matters for me. I am also trying to understand.
This is my also in this nature. First case.
Okay.
Obliged, my lord.
16 to 2000 asane.
Connection with item number 6. But I just had communication with counsel for respondent number 5. Attend lordship due to some personal difficulties.
Who?
Lordship,
Keyboard.
that R. Borua was appearing in that matter. We have contacted.
Who is appearing?
The Lordship wanted to have a-
Agriculture.
Yes,
Who is there?
from Chaudhary is there, but he is in some.
Okay.
Other council is.
Okay, we'll pass orders. Second half. We'll require their name to be reflected, and whenever they are here, we'll do it. Don't worry. Be here when the matter is called up. Yeah. Yes, Mr. Mahmood.
My lord, improved order may be seen page 34. This is a case under Land Grabbing Act. And the Lordship would see the operative portion of the order page.
The appellate tribunal is yet to be set up, I suppose.
Yes.
Yes, Mr.
Michael, page 37. Here, second para, here in the instant case, the principal offense that has been committed by the accused persons are in the nature of criminal trespass, criminal intimidation, etc. So, no case under Section 3 and 6 of the Assam Land and Land Grabbing Prohibition Act is found prima facie established. It will be decided by the special tribunal only after dispossessing the civil liability and then to take resort.
What this
criminal
order
liability.
is not.
Hello?
It had a jurisdiction to decide the issue. Why this? Yes, who are you?
There's another thing, my lord. When there is a special act, land grabbing
It's a
act
special
is
act.
special act. In a special act, there are provisions how the cases shall be tried. But the landed judge is sending the matter before CGM to try under section the provisions of IPC. So that is not applicable.
Who are you?
I am petitioner.
No, means you were the accused or the.
Informant. First I filed FIR.
Then
police
you are the
file
informant.
proceed. Then case was proceeded. The landed court then passed the imprisonment order that it is sent back to CGM to try the criminal offence under section 447, 506, 427, 34 IPC. Our prayer is this: as there is a special act regarding dealing this type of cases, section 3 is applicable of the Land Grabbing Act. So, Land Grabbing Act, if the section 3 is given into effect, then kindly see section 3. It is exactly like in this case, land grabbing in any form is hereby declared unlawful, and any act connected with or arising out of land grabbing shall be cognizable offence under the Code of Criminal Procedure and punishable under this act. So, when land grabbing has been there, and it is not the case of the defendant also, respondent also, that it is not land grabbing, and the learned judge also said it is land grabbing, then why it was sent to the landed CGM to try under the provisions of IPC, when there is a special provision laid down in the Land Grabbing Prohibition Act itself? Our limited prayer is this. Case
Can I interfere?
My lord?
Can I in my writ petition? It's an order, not proper. But can in a writ petition this order be interfered with?
Because
he has
no way.
He has not exercised the jurisdiction vested on him.
Yes.
He has misconstrued it. The provisions of the Land Grabbing Act is that the district, basically two functions in one. Consider the civil liability
And
then whether the land was grabbed. If it was grabbed, then restore it to the person from which was grabbed, and then the consequential criminal action.
Yes, file a title suit, my lord.
That will be there. That can have got no here. But this is a special tribunal.
Now, your lordship can pass order because there is no special tribunal till then is constituted in Assam. Though there is provision.
Land grabbing tribunal is there. The appellate tribunal is not there.
Appellate tribunal in the state level. That's why High Court has accepted this. And this is not only the case, some other cases also.
There are.
Yes. Those cases have been taken up for
Yes, what do you have to say about this order?
Subsection 2 of section.
That is by the authority, by the tribunal, not by the civil court. Both positions. He'll first act as a civil judge, and then he will merge into the role of a session judge.
Session judge.
That has not been done here. Okay, take enough.
Long pending case, my lord.
We'll see. We will today itself. Either way. Take enough. There are few matters fixed at 2. After that, we'll take up your matter. Yes, madam. Industrial disputants. Awesome. Hmm. 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 Madam, the objection taken by the petitioner to this issue is, if I have understood it correctly, is that there was no dispute raised by any of the employees. It was the union who was there before the tribunal. Now, whether the union on its own can do it, I would have understood a situation wherein the union or the secretary was also a worker of that organization. And he has made his statements. The grievance was raised that this is the grievance. So a dispute came from a workman. Here, the persons who are there, they are members of a union, trade union, no doubt about it. But they are not employees or workmen of that organization. So that grievance, that dispute, which is there in 36 manner of resolution of dispute, is not there because the first part is missing. The first part is a workman who is a party to a dispute shall be entitled to be represented in any proceeding under this act by so and so, so and so, so and so. So the issue raised is that who is that workman who is a party to that dispute? Hmm, hmm. No, madam, that list of persons now for this court to verify has to come from the records of the. Why I am saying so? Because there was a question put to you, to the workman, to the person who had deposed. If I can take you straight to that. This is by one Mridul Medi deposition, right? Cross. He says that he is the secretary of Assam Cha Kormosari Sangha. And he says, categorical, there was a question as to who was he representing basically. I have not mentioned the name of any worker who sought for getting gratuity and also pension. Now, madam, this, if we understand it in perspective, that there was none who had a grievance. That's what Mr. Kohli is trying to project. That cannot be taken on record today. Because that was not there as an annexure to your writ petition, nor it was exhibited. Hmm. Hmm. Okay, ma'am. I'll facilitate getting that on record. subject to Mr. Kohli's objections. Madam, show me from any document that this 21 person or any of them had raised a grievance, raised a dispute. No, cannot be. The first time when Mr. Kohli was arguing the question of exposal, I was not with him. But when we went through the matter, then I understood why he is trying to emphasize on that point. Ma'am, come back to 36. Come back to 36. If you can give me a decision on this, I'm with you. Because this is beneficial. I'll ask Mr. Kohli to make that payments to you. But for that, you will have to satisfy me. Paradip is on a different footing altogether. That a lawyer cannot act. Let's come to 36 for my understanding. The 36, a workman who is a party to dispute. I got it. We'll come to that, ma'am. We'll just have 36 first. A workman who is a party to dispute. So the requirement is of a workman being there who is a party to a dispute between the workman and the management, shall be entitled to be represented in any proceeding under this act by any member of the executive or office bearer of a registered trade union of which he is a member, any member so-and-so of a federation, where the worker is not a party member so-and-so by any member of the executive connected with any other in the industry in which the worker is unauthorized. Then you have a subsection 2 also. So, madam, before the tribunal, there has to be a workman who can be represented by a union. No doubt about it. That was not tested. Unfortunately, Mr. Kohli is trying this court to test that. Now let's test your that. Let's understand the conclusion of the Honorable Supreme Court in para 26 of Paradip. Hmm. 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 No doubt about it. This is a provision for the protection of the workman. But the workman should be there. Madam, let us just to maybe not a very correct example. Let's test. You are standing before this court. You are espousing the cause of the workman. Now, can you tomorrow morning walk into this court with a matter without there being a authorization? I'll not call it even a wakalatnama. Authorization by someone involved in the issue. That's exactly what 36 is. If there is a workman, he naturally will not have the wherewithal to contest the mighty management. So, unequal. So, this provision has been inserted. So, he will be represented by a body which has the wherewithal to withstand this. But without that man being there, how can the body do it? That's what is troubling me. And that's what I want your answer. If you can show that if it is an issue which is covering a industry in general, the union, without there being even a reference to a dispute of the workman, a workman being there, it can come up. Just show me that. Understood. That's why on the last occasion, I repeated, Madam, when you make your submissions, kindly factor these two things. Because Supreme Court has also said that this is a beneficial legislation and I should be there to see whether I can give something. Once I find that I cannot, then only I will go with the contentions of the management. Madam, that would be not, no, it cannot be. I can't go beyond this because I'm exercising a power of judicial review now. I can only look into whether the things, there is perversity, the procedure has been followed, plus the additional question that Mr. Kohli has raised. You are that judgment, Paradip. The head note. If we can come to para 12, the last 3 lines. But for a provision like so-and-so, there may have been difficulty under the general law in the way of office bearers of so-and-so representing workmen before the adjudicate. The word is, madam, there is a workman. Authority, unless perhaps regulated by the procedure under so-and-so, to put the matter beyond the controversy, an absolute right is created in favor of the workman in the matter of representation. So the union is not the person having a grievance. It's the workman, and that grievance is aired or fought out by a union. Having made such a so-and-so, the employer is also placed at par with the workman in similar terms under the Act, and the employer may also be represented by an association so-and-so, which the employer is. The right is extended to representation so-and-so. The provisions under so-and-so confer upon the respective parties absolute right of representation by persons respectively specified therein. The rights of under so-and-so are unconditional and are not subject to conditions laid down under so-and-so. The sets are independent. So-and-so, neither the Act provides for parties themselves when they are individuals or companies or corporation. The tribunals being quasi-judicial authorities dealing with rights so-and-so, is not exhaustive in the sense as indicated, so-and-so does not have a so-and-so. So, madam, anything else? We have got your answer on that. We'll consider. Anything else? It is option. Your one is submitted by Mr. Fonidhar Kolita, right? There is a synopsis and a statement of facts in brief. And you have also referred to certain decisions. Statement of facts in brief, then a synopsis. Okay. So 3 documents you have submitted. And have you referred here the judgments that you are relying in the body? 2008 4 GLT 9201. Okay, done. Then you have WPC 2717 2013. Done. Assam Nagaland 39. Namburi Nadi so and so. Then okay. Hmm. Hmm. Ancillary incidental powers, huh? And the judgment of the jurisdiction of this court. And you have also relied upon WPC 271720. Okay. Your Kolita, kindly have this, I'm giving you the file. The judgments that are relied upon, it's all jumbled up. Can you just put it in one place along with the, just put it in one place, no need even to staple, just put it in one place.
Yeah, Lordship.
Yes.
Lordship, there is no doubt it's a beneficial legislation. No question about it. And let me satisfy Lordship on what Lordship asked so that our conscience is clear. Can we come back again to the workman's cross-examination? That because Baido was saying, my learned elder sister was saying that we have a list of 21. So I want to satisfy Lordship on that and then just make my closing arguments. On top was, I have not mentioned the name of any worker who has sought for getting gratuity and also pension.
Next line also. Yes, yes.
I have also not submitted a list. Now, Lordship may come to leave the next para and the next para. At present, the management of the tea garden are paying gratuity and also pensionary benefit as per the said rule. Please mark, Lordship. All the retired employees opted for gratuity in lieu of pension and they are still receiving accordingly.
I've already marked.
So therefore, Lordship, if there was not any one of these, if one of these was not being complied, I would say I would have an issue. Second, Lordship has already got the core point that at 36 of workman has to be a party to a dispute. Only then can the representation...
The union would be like an advocate coming in.
It is perfect to that. Now, Lordship, the main point is our case is that 2K is not satisfied at all, which is what is an industrial dispute.
What prevented you, Mr. Kohli, from coming up before this court at that stage?
Lordship, let us put it like this, Lordship, I got engaged subsequently.
No. I don't mean you.
I mean what you're saying, Lordship.
I mean your...
Lordship, I will grant credit to the advocate who handled it in the tribunal because the cross is worth its weight in gold. I really would appreciate that.
He had asked questions.
It's worth its weight in gold, Lordship. And I think I would compliment the management, whoever and the advocate did it, because that cross is what clarifies the errors in the award. Now, Lordship may see 2K. Industrial dispute means any dispute or difference between employers and employers, or employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or the terms of employment. Now, Lordship, respectfully, this per se is not satisfied. It is not an industrial dispute, hence the reference is wrong. Having said that, Lordship, I'm going in reverse order. If I come, Lordship, to the award itself and the last paragraph, that is, Lordship, at page 47. So, Lordship, the reference per se, the issues are on 32, but the final order of the award is on 47. Now, Lordship, in context of it not being an industrial dispute, what is the final order devolving onto me? That therefore, in view of the facts and circumstances settled legal position, I don't feel any hesitation in holding that the action of the management regarding refusal of pension, which is contrary to the record, paying only gratuity, again contrary to the workman's own stand, to the retired employees is neither legal nor justified. Next is critical. Accordingly, it is held. What is the direction? That the management is hereby directed to make a bilateral agreement with the union within the period of 2 months in relation of payment of pension to all retired and or to be retired employees. Now, Lordship, this is not even the reference before the tribunal. In legal terms, Lordship, can a court pass an order on something that is not the list before the court? So therefore, Lordship.
Mr. Kohli, just to put it in a different manner.
Yes, Lordship. I am with
you. The tribunal was, what you said is correct. The tribunal was to decide the issue and give an award, either granting or not granting. It could not have put a further direction to the tribunal, to the management and the parties to enter into an agreement. That's something which will be coming under 18. The persons will look into it. But here, the tribunal has not taken a call with regard to the benefits which will be receivable by the person in dispute, which again goes to show that there is a vagueness about the person whose grievance is actually looked into.
It is trying to craft relief in the face of the lack of evidence. Now, Lordship, having said so, in 6 sentences, what is my case? A, no objection by any worker on clause 7, which is what was the 1971. Second, no worker approached the tribunal, neither is the union able to show espousal to them by a worker. No document by the union or a worker to show that they opted for pension and they were denied, which is the negative against me, not there. On the contrary, the workman's own evidence that everybody was receiving it. This is coupled with the received stamps, Lordship. They are old documents. And Lordship, once a receipt, that's a very, very good evidence in my favor. Our consistent stand, so now I shift to us. Our consistent stand that everyone did apply and opt for gratuity, and no evidence contradicting our stand. So at every level, I'm there to satisfy the court. Last is, Lordship, delay and latches. That's why I come to it last. Because actually, that's my strongest point in terms of law. After 42 years, you can't have this. It's beyond the reference, it is beyond time. Now, Lordship, I wish to, for a moment, come to my written submissions because I would like to distinguish 2 judgments put by my learned sister. Page 20 only, Lordship.
Give me 2 minutes.
Of course.
Madam, one more further query. Let us see. As Mr. Kohli had said, let us keep our conscience clear. In your written statement, is there any indication of the workmen involved going before the management or before the authorities raising a dispute and then you taking it over? Not there. Okay. Yes, Mr. Kohli.
Page 20, Lordship may come for a minute.
Fine.
Of my written submission.
Because I was pursuing seeing that, but I did not find any material as to who had approached the conciliation officer, the failure of the conciliation. It's by the Songol.
In fact, Lordship, in fairness, not as an argument point, the Songho's own stand in its affidavit, not in the cross, is that we want to get a new
system in place. On that, madam, you still have the way out through the agreements, which is contemplated under Section 18. You still can do that.
Yeah, my lord, next that is exhibited repeatedly, my lord, Sangha.
Okay, we got it, man. We'll consider that. We'll consider that. We'll consider that. Yes, Mr. Kohli, what do you want to say
Page 20, Lordship.
of your written
Written
argument?
commission. I'm just showing one paragraph to show how I distinguish their judgment.
The judgment of our High Court.
Yes.
Hmm.
So, Lordship, they are referring to the judgments, and the main one being Varshavi Tea Estate versus Lordship may come to 21. Please read the paragraph in italics, which is the para 12, Lordship. In that judgment, nothing was incorporated in the scheme to indicate that the benefits payable under the retirement scheme would be withdrawn if similar benefits are made available to the workman under statutory obligation or some obligation. However, the present case is distinguishable on the ground that clause 7 of the 71 scheme explicitly provides employees with the option. So in that case, this didn't exist. In my case, my agreement has clause 7. That's the case. And sealing, Lordship, is relying upon Varshavi. So hence they are distinguishable. My fact is different. I'm so deeply obliged, Lord, for the very, very patient here.
Anything more, ma'am?
Very good.
Third, Mr. K. Kohli, learned counsel for the senior counsel for the Mr. K. Kohli, learned senior counsel, assisted by
Anshul and Mr. Kankalita. Anshul
Mr.
Malik.
Anshul
Malik.
A. Malik, and Mr. K. Kolita, learned counsel for the counsels for the petitioners. Also heard Ms. A. Bhachaji, learned counsel, appearing for the respondent. So, hearing concluded, raised to list this matter again on delivery of orders. 19 ase kataman issue lot man dedicated. No lage. Vacation on the last week to ki motion week kam nahi 23 kori dia.
23.
Beleg nidi bhai na. Na yaru hek boria. 23.
20. So deep here.
You need not be here. I'll deliver
I'll
the
come
order.
on VC.
You can come on VC.
I'll come on VC.
Don't want to
I'll
trouble
give
you.
that permission for VC. My friend will.
Granted.
Grateful, Lordship.
But interesting.
It's a very interesting case.
Now,
Lordship, I also must confess that it was one of my first ones in industrial dispute. We had to study it.
I have not done much.
Yes, Lordship, because we don't, in our normal practice, we don't get. I have to, on the contrary, say, when they told me she's there, I checked her background and said, or homework karo.
Madam is an expert.
Yeah, of course. That's why.
He is on a back foot because of the facts.
Only because of the facts. And that's why I'm playing on the facts. Deeply obliged.
Yes, madam.
It is a luxury. My lord, that question, my lord. It did not make me sleep, my lord, last 2-3 nights. My lord.
But I sleep very comfortably at night because I finish everything, all the queries before that. Yes.
While I surrender, my lord, while I surrender, because
Madam, mind your statement. If you surrender on that, your writ petition will go for a 6.
Yeah, I know. I understand, my lord. While I said, my lord, one thing I'll point out, my lord. We are in a 226 and that market is of the Jaleshwar Anchalish Panchayat. There is no dispute to that effect. Now, only the question of locus.
Not the locus. Person aggrieved. 2 words you will have. Then the locus would come.
Person aggrieved. Both, my lord, both. I need to answer both. My lord, what has been challenged here is the order dated 35/2025. What does it say? It says that the Gaurnagar, the opponent market matter, the Gaurnagar so-and-so market shall be, is allowed to reopen on Friday. That is the order under challenge. If the order goes then also they have the freedom to continue with the trade because there is no embargo. If the order remains, what is going to happen? Only this is going to happen that the Anchalik Panchayat who has the land on lease on a Friday only will not be able to function. Now, when I say this, my lord had asked me, and very pertinently, my lord, that I knew I will invite that question, that from where did you get the authority? Here, I will make one fact clear, my lord. More than 1.5 years, there were no elections. The previous body had, the time had elapsed, my lord, the time had expired. So there was no elected body. The elections happened only some time back, and the body has taken over sometime, I think, first
of August.
not August, sometime in the first week of August. So during the transition period, who am I is still a question that remains. There was some kind of authorization which may not be legally valid. Maybe if I take it for assuming, but not admitting in, my lord, assuming that there was some, there was, my lord, this assumption is there. Whether that authorization can be legally sustained or not is one question which I need to deal with.
Cool down,
My lord,
cool down.
my lord.
Now you have come to the point. Legal authorization. Your orders refers to resolution number 2 of a particular meeting. We have all perused that meeting. There is no reference to you.
My lord, before that resolution, there are other resolutions also. I do not know, my lord.
Madam, that is for you to, because in your order that you say, it's only a resolution which is referable to a particular date. We have perused that. You are not there. It is only one Shah Alam who will be collecting the tolls. So, ma'am, where have you parachuted in from? If I may use that word.
My lord, to this I will respond this way. Is a Jaleshwar Anchalik Panchayat, that new body has come, they must be having the records if they can help.
Okay, then we'll have a dialogue with Mr. Bora.
In this, I point out one more thing. Whether, because so far as the opponent is concerned, they want it on Friday. For myself, I am concerned.
Madam, we are there to hear that issue. We are here to adjudicate that issue, but that issue should come before us by a person having authority.
My lord, my lord.
Give me 2 minutes. Maybe it will come in your favor. Give me 2 minutes. Yes, Mr. Bora. Who are you? You are the present body. What is this arrangement you have made with madam?
I just before we have been newly elected.
Okay, fine.
We have come and there's an peace agreement. Then for 5 years, and we operate on Fridays. The order by the commissioner. Kindly see why I have the order of my lord.
The commissioner.
No. Why your lordship the order of 39/2024 passed by the secretary. But the commissioner secretary.
Mr. Bora, for me to understand, that is not before me.
Yes.
That writ petition is not before me. You have a cattle market, a weekly market. You have decided, you means your earlier body, that you only have decided that you will operate it on Friday. There were some disputes with that. Now, the issue in this writ petition is, who is the petitioner in WPC number 338925?
I know that he is an operating market.
How?
How? Because it here also. A tender by sorry. So now he has been
There is no stay.
no stay, but only thing is why, yes. But whether what he's selling the order of 2024.
It is qua the private respondent, not qua the your market.
Now, kindly see when this order, which it
Just
it is
tell
not-
me the power under which she has been or the petitioner has been engaged. Who has engaged her?
earlier body has said.
Where is that resolution?
Earlier body has said.
There is no resolution.
I have not gone through the.
Mr. Doctor has produced 2 resolutions before us. Any reference? Any?
I think on
Now you have, now what is the order you have challenged in your writ petition?
in my petition, I have challenged the order of my lord, 35 2025.
No, I don't know. That writ petition is not before this court.
My lord, definitely. They have filed today.
Today.
They have filed.
Can you just show me what is the order review which you say has been reviewed?
First, if your lordship will.
Page 60?
Order.
Hmm.
This order by, my lord. And what? Go to the deputy commissioner, file an application, and they will decide. Then this and rural development has given a written orders.
Page.
Paragraph 4.
1, 2, 3, 4. Where is the so and so?
WPC number.
Private market on Hubs and then a
I ordered it at W. I'll just skip this thing. I'll come straight away the last paragraph with the whereby last whereas that is a Valpara. Right, CD number has ordered that weekly market of Basmura Posuhat will run.
Basmura Posuhat is the Anchalik Panchayat's market. Okay.
Run
Their market every Friday.
Every Friday, that is number 1. Then, as for the existing, that Goranga Priest and then we on every Monday or Wednesday. The other party, Monday or Wednesday. That has been given.
So this is Friday to you, other days to the private respondent.
Yes.
Then
Friday for me and other for the switch. Now, this order has been challenged. Where?
challenged by Madam. No, by them. By Ms. Chaudhary. Then no interim order.
No interim order. While the matter was being now kindly see.
So 35 2025 you have challenged.
Yes.
Now.
then 35. 35 for that. What it says, Lord, this order on the face of it, Lord, at direction of somebody else. And number 1, mention of the writ petition. Number 1 is kindly see the order. Because the matter has been pending here. It is say anything about to turn DDC, my lord. Now, what concern DDC has? In pursuance, my lord, kindly see the order dated 5/2025. In pursuance to the communication of my lord, see MLA 39.
Got it.
But when the MLA has the communication to the DDC, file later and report to the circle officer so and so. Permission is accorded to someone. So and so is on file.
Enough, Mr. Got it. Yes, madam. The Panchayat is before us now. Why should we continue with this writ petition? They have already filed a writ petition challenging the same very order. And they are the appropriate party to do that.
That is what I wanted to say when,
Okay.
it's clear.
You want to withdraw this or should I dismiss it?
My lord, since my lord, there is an interim order and that other writ petition is not here. And as I just wanted to add, for me being there is not important.
Okay.
Let the bazaar remain, my lord. Let
Is
the
there an interim order operating in your case?
Yes, that 30th May is, there is a stay, my lord. Whether I am there or not is not important.
At the
to be honest.
Learned Council for the
I'm grateful
parties
to
at
you.
length. Also, during the course of the hearing, Mr. P. Bora, Learned Senior Counsel, appearing for the Jaleshwar Anchalik Panchayat, who has sought impleadment in WPC number 237-2020. Madam, 237-2025. Impleading. Who has sought for impleading in 3389-2025 has submitted that a fresh writ petition has been filed by the Jaleshwar Anchalik Panchayat presenting a challenge to the order dated 30/5/2025, which is also under challenge in WPC number 3389-2025. Full stop. As agreed to by the Learned Council for the parties, a registry to list this matter, raised WPC number 3389/2025 along with WPC number 237/2025 to list WPC number 3389/2025 and WPC number 237/2025 along with filing number WPC bracketed filing number 11214/2025 on the date the same is listed for motion hearing. Done with. So the appropriate party is here.
It's okay. As it is, I'll have to give away now because the body has.
Because the order, that interesting, the order the district magistrate has or the district collector has varied is an order of the government. How can he do that?
It's correct, my lord.
Rejected. Rejected. That will be considered once a stay is passed in, Mr. Pran Bora, because an apparent illegality is there on the face. That is why this court is not inclined. You want to press that application, I can hear it. Everything will come, whatever is there, along with all interlocutory applications, pending interlocutory applications. So the motion matter, whenever the motion matter comes up, this will also come up.
My lord, in the meantime, my
Your REA, you will consider there.
for impleading.
Today, unfortunately, this matter, this aspect was not, because we were with the locus of Madam. So Mr. Bora has highlighted the fact there was an order from the government.
I've seen
Now, the government's order, how can a district magistrate go contrary to that? Review, it cannot.
Is the power for review or not?
No, my IA for
I can allow this. I could have allowed, if it was not the question of locus, I would have allowed the writ petition today. Madam's writ petition. But there is a stay. Let it be there. Let an illegality not be perpetuated. Because by dismissing her case, I will be vacating a stay order, which will give rise to an illegal order. I don't want to do that. Let there be a final hearing. The motion matter should come. I have said on the day it is fixed for motion. You also ask your advocate's clerk to get it listed at the earliest.
My IA is in respect of that writ petition, not this writ petition.
Any writ petition. Interim order passed earlier to continue till the next date of listing. Yes. Yes, madam, sir, what is your name?
My lord, myself is RV Birade, is the electrical, BSNL Guard.
So last date your council had given an undertaking that you will finalize the amount. Why was this amount not finalized?
Approval of
When is the date of the accident? Date of the accident? 22. 22. And you have taken 3 years now. More than 3 years. Why? The report of the electric inspector is before us. And it clearly indicates your negligence in the matter. You are liable to pay compensation.
Harihara side of BSNL tower.
If you are denying that you are not liable to pay, just tell us, we will decide the matter. Just make a submission that your advocate had made a wrong submission and you are not paying anything, you are not entitled, we'll see the rest. Rest you just leave it to us. Yes? Mr. Officer, yes. You are not required to make a submission that you are going to pay. But you are at the same time empowered to say that we are not paying, we are not liable. Make that submission, I will record it, we will pass orders. But thereafter, the interest will be calculated, that interest component will come, that I will get it recovered from each of your officers, guaranteed. If we finally come that the petitioner is entitled to a compensation, I'll make it payable from that day along with compensation. Do you have the last order? Last date's order? Yes, what is your submission now?
3 lakhs rupees.
Put it on an affidavit. And how have you come to that conclusion? How have you come to that conclusion? 3 lakhs. Big amount. How did you come to compute that? Give me the basis. 2019, what is the minimum amount payable? 4 lakhs. Then how do you pay 3 lakhs?
100% developed by
Mr. Officer, the APDCL says for permanent disablement. This is permanent disablement.
Permanent.
It's around 4 lakhs in that more table. A jointly file to that a notification to the assessors.
Wait one thing. I have pleaded here. I rely on full judgments of the Supreme Court.
We'll come to the judgment subsequently. APDCL has it says 4 lakhs. How much it is? APDCL 4 lakhs. So you are liable to pay 4 lakhs. Right? When are you paying?
Approval of our author.
How can you make a statement if there is no approval? And what were you doing from the last date? Approval, why approval was not taken? Can you have your instructions? We'll take it up after half an hour. You have your instructions, the time frame within which you will release that 4 lakhs and interest we will calculate. We will provide for, and the rest we will provide for. So please have your instructions. Come back after half an hour. I want a commitment that within this date, this amount would be paid. And Mr.
My prayer is for 50 lakhs.
50 lakhs, why 50? You can have 1 crore also. For that, the provision is there in the guidelines itself. You will have to approach the civil court. I'll give you liberty.
Here, my lord,
4 lakhs with interest from the date of the accident.
Kindly see. Here, my lord, High Court decided, High Court gave my lord 1 crore 25 lakhs, then Supreme Court reduced it 90 lakhs. And only question is that, my lord, there were double amputations, here single, but amounts to double because my left hand also, my lord, is useless.
Okay.
And this one also may kindly be full.
Mr. Officer, you can have your instructions.
Husband's copy to the
Okay, fine.
council also, department also, for perusal of the judgments. All factors, my lord, have been.
Mr. Mullah, you want to have an argument, you want to hear this matter, this court to consider the compensation. You want this court to consider the compensation? Okay. Now, come to the assessment. এই সাইডত আছে সাইডৰ ফালে যোৱাকালি মেটাখিনি যিখিনি মই ডিক্টেশ্যন দিব তাতে আগৰৱালাই কেছ কৰিছিল এটা তাৰে কেছটো অ'কে let us see the expenses you made towards the medical treatment.
Medical, my lord.
How much rupees have you
So for
spent?
the Bowser, my lord, I have annexed here, my lord.
What is the total amount?
Here, my lord, 2,79,346, my lord.
So,
and thereafter, it is also continuing, my lord.
Okay. Okay.
And my lord, kindly see, one hand is amputated, there is another, that is.
I am providing for that. You go before the trial court, establish it. Why 50 lakhs? Even 1 crore is enough for you.
I rely on the judgments. That is not, my lord, that has not emerged from the lower court, my lord. High court decided, it gave, my lord, 1 crore 25 lakhs. Then Supreme Court reduced, my lord, in appeal, and then gave interest also. It was reduced to 90 lakhs. And in another, my lord, 2 judgments, my lord, I have given.
One is Mohammed Hakim. That is a case coming up from the MSCT.
That is MSCT, my lord. But left leg, my lord, was amputated.
Mr. Mullah, that is not the way you make argument for compensation.
Then, my lord, this Nabal Kumar, my lord, this may be considered.
Okay, we'll pass our orders. Let the officer come back. You get your instructions. We'll pass the orders.
May kindly be considered, my lord, Nabal Kumar. And here, my lord, assumption and presumptions also are discussed, my lord. Paragraph 9, my lord.
How old is the child now?
Now, my lord, 12 years. At the time of, my lord, he was 9 years, 9 or 10. Or 25 is running. So.
Okay, let the official come.
My lord.
We will go by the circular, but we will make provisions that you are entitled to a compensation, which you will establish before the civil court.
For that, I would pray, my lord. Your lordship may be pleased to go through Nabal Kumar, my lord.
Nabal Kumar, I have seen it's a one of a case.
There is no issue of civil court, my lord. High Court decided, and then Supreme Court finalized it, my lord.
The order passed by this court will not be the end of the matter. Appellate court is there.
I'm saying only that issue is not here, my lord, in Nabal Kumar.
That is me. Let us get you something first. Then we will see what can be done.
Or they have come with an amount, that cup of tea, my lord.
Okay. Have a cup of tea. You're not having anything till now. Have a cup of tea at least. Then we'll see what can be done. Okay. Let the amount come, then we will decide.
Obliged, man.
6.
Register to list this matter again on 10th. Mr. Borua will not be here. Okay. On 8th, 9/2025, reflecting the name of the Standing Council Agriculture in the cause list. Let him come, let her come. She may have missed out. So on the next date, we will see what can be done.
Public.
Why? Okay, we are there. You navigate. Yes, madam.
Item number 6786 WPC. Dear Lordship,
Madam, there was an order passed by the competent authority.
Lordship.
Were your services provincialized? Your services was not provincialized. The services of the writ petitioner was not provincialized, right? Have you challenged that order in any forum?
Lordship in 6786 Lordship.
6786.
Lordship.
Okay. 6786 studio.
That is put to challenge here. Lordship.
Okay.
Lordship.
Any order passed here?
Lordship had passed an order, Lordship, referring the matter to the tribunal, Lordship. Then
No, that was in the other writ petition.
Lordship. The other Lordship had passed an order. So that order is put to challenge in 6786 Lordship. WPC, there is another order.
So, both of you have not been able to, has he instituted a proceeding before the tribunal till now?
No.
You have not instituted. Why? That is the first instruction you should have. That means you have not done it. We will get your instruction whether he has filed or not. If not filed, we will think about something else. Mr. Chaudhary, that is the first thing. You will be informed whether the order has already been complied with.
That much, my lord.
How? How? Where is that impugned order? Which was challenged in the other writ petition?
6786 Lordship.
No. The order which is challenged.
Page 172.
170.
In 6786, page 172. Operative part, page 174, the grounds for rejection of the petition.
You are
I'm Ahedul Hussain, Lordship. Page 174. First, they have stated there are some
here the services of the petitioner was not provincialized, nor yours. And today the petitioner is continuing.
No, Lordship, nobody is continuing.
Nobody is getting provincialization benefits.
Earlier, the petitioner
That was done away with.
Lordship, that he received salary also, violating the court.
You also go before the tribunal.
Lordship,
Around 5-6 rounds of litigation is over.
Lordship.
It has not taken anywhere.
Lordship, all the issues has been decided earlier in another round of litigation. All the issues, now they have come up with the issue that was already
Give me one point
Lordship.
to review my order. One argument.
The review petition, if Lordship takes.
You will get it in the second paragraph of the order.
Stated the grounds, Lordship.
Forget the grounds. Give me one ground, which you will get in the second paragraph of the order.
All the aspects has already been clarified earlier, Lordship. They have.
Madam, give me a ground for review. Opening paragraph, subpara.
Page 86, Lordship.
Make a submission from there. I'm reviewing the order.
The challenge that starts here. Lordship. The challenge.
No, before that. Para before that.
In view of the order being proposed to be passed in the present writ petition, notices upon respond number 3, 6, and 7 at this stage is not deemed necessary.
I have not heard you. That is a ground of review. Yes. No. Review petition 85. You are appearing, Mr. Chaudhary. Why have you not instituted a proceeding till now? That is not the ground. That is not the ground. We are reviewing this order. We are recalling it. We have not heard her. Now she has also filed a writ petition. We'll hear both the writ petitions together. But Miss A. Taluk Learned Counsel for the petitioner. Also heard Mr. D. Chaudhary, Learned Counsel, appearing for the respondent number 6. Also, the present review petition has been instituted, praying for a review of the order dated 21/12/2023, passed by this court in WPC number 6211/2023. Also, the writ petition being WPC number 6211/2023 was instituted by the respondent number 6 in the present review petition, presenting a challenge to an order dated 16/8/2023 by which the Secretary to the Government of Assam, Department of School Education, had rejected his claim for being provincialization of his services. Also, while the order dated 16/8/2023, the respondents had rejected the claim of both the present review petitioner as well as the respondent number 6, herein, for provincialization of their services. Full stop. This court, wide the order dated 21/12/2023 on noticing the grounds as raised by the noticing the reasons as assigned by the respondents for rejecting the case of the review petitioner as well as the respondent number 6 had required the respondent number 6 herein, to approach to institute proceedings before the jurisdictional educational tribunal for a determination of the rights of the review petitioner herein as well as the respondent number 6 herein for provincialization of their services. Also, subpara, Ms. A. Talukdar, Learned Counsel for the review petitioner at the outset has submitted that the order dated so and so was so passed without affording an opportunity of hearing to the review petitioner, and accordingly, on the said count itself, the order dated 21/12/2023 would mandate a review. She has further submitted that the proceedings directed to be instituted in the matter by the respondent number 6 herein by this court-wide order dated 21/12/2023 before the educational tribunal has not been instituted till date. Also, accordingly, she submits that, Ms. Talukdar further submits that being aggrieved by the order dated 16/8/2023 passed by the Secretary to the Government of Assam, Department of School Education, the review petitioner herein has also instituted a writ petition being WPC number 6786/2023. However, when the order dated 21/12/2023 was so passed, the said aspect of the matter was not brought to the notice of this court, although on the said date, the review petition, the petition being WPC number 6786/2023 was pending disposal. Full stop. Mr. D. Chaudhary, Learned Counsel for the respondent number 6 hearing, respondent number 6, hearing, has submitted that on account of the fact that WPC number 6786/2023 was pending disposal, the respondent number 6 had not instituted the proceedings before the jurisdictional educational tribunal. In view of the above factual matrix as brought on record in the matter, and this court having passed the order dated so and so without affording an opportunity of hearing to the review petitioner, and the order having the effect of adversely affecting his interest, there being a proceeding instituted and pending on the date instituted by the review petitioner in the form of a writ petition being WPC number 6786/2023 and pending disposal on the day when the order dated 21/12/2023 was so issued, further, no proceedings having been instituted by the respondent number 6 herein before the educational tribunal, this court is of the considered view that the order dated so and so would mandate to be reviewed, and accordingly, the order dated 21/12/2023 stands recalled. Full stop. Registry to list WPC number 6211/2023 to its original file and list the same along with WPC number 6786/2023 and other connected matters after 2 weeks on a date to be fixed by it. Done.
Highly obliged, sir.
If you had filed that proceeding, Mr. Chaudhary, I would not have reviewed the order.
Again, the same order.
You should have brought it to the notice of this court. Nobody brought it to the notice. Anyway, fine. Yes, Mr. Within a month. Okay. Have Mr. Mullah here. Your name is?
R.V. Birade.
Can you just write down in a piece of paper? Heard Miss Goswami. Your name? G. Kolita. T. Kolita, learned counsel representing Mr. R.J. Das, learned standing counsel, BSNL. (31st October), no problem. 31st October, but it has to be paid on 31st October, okay? Along with the interest, which will be calculated from that day. Submits that Mr. So-and-so, just write down his name and designation, is present before this court to assist this court in the matter. Full stop. This court had an interaction with Mr. So-and-so, so-and-so, who has submitted that an amount of rupees 4 lakhs would be paid to the petitioner as a compensation within 31/10/2025. Full stop. The said amount be so paid to the bank account of the petition number 1 is the father. To the bank account of the petitioner number 1. Also, the said amount shall be so paid after, along with interest at the rate of 9% from the date of the incident till the date it is so deposited in the account of the petitioner number 1. Full stop. At this stage, Mr. R. Mullah, learned counsel for the petitioner, has submitted that he would make further submissions with regard to the entitlement of the petitioners for a higher compensation considering the nature of the injuries sustained by the petitioner number 2 Full stop. Accordingly, this court requires the registry to reach this matter again on November 6th, 6/11/2025 for 6/11/2025. On the next date of listing, the Standing Council BSNL shall apprise this court as to whether the amount as undertaken to be paid by amount of compensation undertaken to be paid today and reflected herein above in this order, along with the interest, has been deposited in the account of the petitioner number 1. Full stop. Thereafter, the parties would be at liberty to make further submissions with regard to the claim of the petitioners for higher compensation.
Published.
31st. Mr. Nat, you have gone through anything?
My lord, I haven't seen the records. I have seen the records through him.
No, fine. Mr. Doctor
And I trust my friend, my lord.
Yes.
And my lord, so far, rest I leave to Lordship's, my lord. Lordship has seen that. Lordship has seen my 54. Lordship decide the matter. That's all, my lord. Because I can't improve what is in the records.
This is before a red court, Mr.
He could have filed the suit at relevant point of time. He did not.
That we will not go into. Okay. Third, Mr. M. Nath, Learned Senior Counsel, assisted by Mr. A. Pachaji, Learned Counsel for the petitioner. Also heard Mr. M. Doctor, Learned Counsel, appearing for the respondents. All the respondents? For all the respondents. Full stop. The petitioner in the present proceeding has prayed for a direction upon the respondent authorities to refund an amount of rupees 7,72,100 words or lihidiva, which was projected to have been so charged from the petitioner as upfront fees, upfront bracketed processing, upfront processing fee for sanction of cash credit limit to the petitioner. Petitioner number 1 concern. Also, as projected in the petition, the petitioner had approached the respondent number one bank seeking financial assistance for setting up of a shopping mall cum multiplex at Kelvin Cinema Compound, Guwahati. Full stop. Basing on the said request and on making and on processing of the matter, the respondent number 1 bank wide communication dated 5/11/2009 had agreed in principle to grant overall financial assistance of rupees 800.00 lakhs, 800 8 crores rupees 8 crores bracketed in the form of cash credit. Also, they said approval granted was also hedged by certain conditions. Also, one of the conditions required to be met by the petitioner was with regard to payment of an upfront fee of rupees 8,82,400, which include debt service charges. Also, it is seen from the materials brought on, it is further projected in the petition that the said loan was said financial assistance in the form of cash credit as authorized to the, as approved to the petitioner was secured by the petitioner by hypothecation of both a hypothecation of land and landolina, Hypothecation of land? Hypothecation of movable and immovable assets. Full stop. It is further projected in the repetition that the respondent bank had converted the cash credit limit, comma, to the extent it was so drawn by the petitioner, comma, that is rupees 1 crore, as a working capital demand loan, while a communication what 31/7/2012. Full stop. It is seen that the cash credit limit utilized by the petitioner, which was subsequently converted as a working capital demand loan, was refunded by the petitioner. Mr. Doctor, kindly, if there is any error in the facts, kindly put, was refunded along with interest by the petitioner, and the account came to be closed by the bank authorities. Also, the petitioner thereafter preferred a representation on 19/1/2013, and therein inter alia raised a contention that the upfront processing fee having been so deposited by it, having been so received from it by the bank for the grant of 8 crores as working capital, comma, the petitioner having only withdrawn rupees 1 crore, comma, the processing fee for the remaining 7 crores not utilized by the petitioner be refunded to it. This is the case. The said refund not having been made, comma, the petitioners have instituted the present proceedings. Also, Mr. M. Nath, learned senior counsel, appearing for the petitioner, after reiterating the facts as noticed herein above, has submitted that the reason assigned for by the respondent bank for not refunding the amount received from the petitioner in excess of actual drawal by it of the credit limit authorized to it was on account of non-renewal of the said financial benefit extended to it by the bank authorities. Mr. Nutt, by referring to a communication dated 7/1/2011, which was so made in pursuance of 7/1/2011 issued by the petitioner in response to a communication dated 7/12/2010 issued by the bank authorities, has submitted that the petitioner had furnished all requisite information for a renewal of their limits. However, the bank refused to extend the said refused to renew the financial assistance extended to the petitioner in the form of cash credit. It's called cash credit limit, na? Cash credit limit, apostrophe, very well. Full stop. Accordingly, he submits that the petitioner not having utilized the entire cash credit limit and the bank having restricted utilization of the same only to the extent of rupees 1 crore. The processing fees which was admittedly received from the petitioner for authorization of cash credit limit to the extent of 8 crores, the excess so received from the petitioner is now required to be refunded to it with interest. Anything more, Mr. Nath? Mr. M. Dr. Learned Counsel for the petitioner at the outset has submitted that the cash credit limit was authorized to the petitioner basing on an application submitted by it in this connection. Also, basing on the projections made in the said application, the bank had at the outset agreed in principle to grant an overall financial assistance of rupees 8 crores in the form of cash credit facility to the petitioner firm. Also, as per the policy of the bank, for processing of the cash credit limit, for authorization of the cash credit limit benefit to a customer, a upfront processing fee of 1% of the sanctioned amount plus service charges is required to be received from such customer. Accordingly, the petitioner herein was required to deposit an upfront fee of rupees 8,82,400, which it is submitted that the petitioner had duly deposited with the bank authorities, and thereafter the petitioner was at liberty to utilize the cash credit limit given to it. It is submitted by Mr. Dotto that during the processing of the matter, while proceeding to determine the drawing limit required to be authorized to the petitioner, it having come to the notice of the bank authorities that the petitioner had not complied with certain conditions, i.e., certain conditions, including the condition for increase in the promoter's share in the project in question, the drawing limit of the petitioner was fixed at 2 crores. He submits that the said fixation was so made initially, however, the same was permissible to be increased subsequently basing on the transactions so carried out in the matter by the petitioner. Also, where is that letter that he is to have 1 crore? Also, Mr. Dotto submits that although the petitioner was eligible to draw rupees 2 crores as cash credit limit, the petitioner could only draw 1 crore. Also, if submits that the said amount of cash credit of rupees 1 crore granted to the petitioner not having been refunded, and the same came to be converted as a working capital demand loan, and the petitioner was to now refund the same along with interest. Also, he submits that the petitioner, having failed to act in the matter by complying with the conditionalities put for utilization of the maximum limit of 8 crores as 8 crores of cash credit limit as authorized to it, the bank authorities are at no fault in the petitioner not being able to process the said cash credit limit to its maximum. Also, Mr. Dotto has further submitted that the bank authorities have submitted that the petitioner on submitted that the said cash credit limit was so extended to the petitioner on 5/11/2009, and the processing fee was so submitted furnished by it on, what is that second letter? For processing fee was furnished by it on, there is a letter 11/1/2010, comma, the petitioner had at no point of time before 2013, more particular specifically 19/1/2013, demanded refund of the purported surplus amount charged from it towards as a surplus amounts charged from it as processing fee. He submits that the said demand came to be made by the petitioner only after the closure of the loan account, and the same was so made widely representation dated 19/1/2013. So in the above premises, Mr. Dr. submits that the petitioner has not made out a prima facie, submits that the petitioner's claim for being refunded the excess of the processing fee purportedly received from it by the bank authorities could not, would not mandate an acceptance from this court. I've heard the learned counsel for the parties and also perused the materials available on record. The facts as noticed herein above is not in dispute. Also, it is further not in dispute that the petitioner was authorized a credit limit of rupees 8 crores by the bank authorities by a communication dated 5/11/2009, and the same was so authorized basing on a request made in the matter by the petitioner. In terms of the terms and conditions attached to the authorization of cash credit limit to the petitioner, the petitioner was required to deposit an upfront fee, which was to be computed at the rate of 1% of the sanctioned amount plus service charges. The amount payable being 8,82,400, the same was paid by the petitioner. Also, was paid by the petitioner. I have not said anything about refundable. Also, the petitioner was thereafter basing on the fulfillment by him of the conditions prescribed in the matter, authorized a drawing limit of rupees 2 crores by the bank, which also the petitioner drew rupees 1 crore against the cash credit limit extended to it. Also, the amount as drawn by the petitioner not being refunded within the period the said facility was so available to him, financial facility was so available to him, the said amount was converted as a working capital demand loan. It is projected that the petitioner had not renewed his working capital, his cash credit account, and for the reason of which the amount, the drawing power of the petitioner came to be limited to 1 crores. Full stop. The materials, the records as produced by Mr. Dotto has also been perused by this court, and it is seen that the petitioner without any objection, had continued to enjoy the cash credit limit only to the extent of rupees 1 crore with till the closure of the account, till the closure of the working capital demand loan extended to it on conversion of the cash credit limit drawn by it. It is after the conversion closure of the said loan that the petitioner had approached the bank authorities via the representation dated so and so 19/1 to 2013, praying for a refund of the amount purportedly drawn excess as received in excess as upfront fee from it. Full stop. The materials brought on record in the matter having demonstrated that the bank had authorized to the petitioner a cash credit limit of 8 crores. Wide communication dated 5/11/2019 were willing to allow the petitioner to operate the same at the maximum limit. However, on account of the non-fulfillment by the petitioner of the conditionalities put in the matter, the petitioner having only been able to draw an amount of rupees 1 crore therefrom, the same also having been defaulted in repayment, require reading to conversion of the same to a working capital demand loan, this court, considering the policy of the petitioner bank, of the respondent bank, that the upfront processing fee received from a customer would not be permissible to be refunded and can be refunded only in the event the financial facility for which such upfront processing fee was received is not authorized to the customer concerned. Also, in view of the specific stand taken by the respondent bank in the matter, and there being an admitted default on the part of the petitioner in refunding the cash credit limit to 1 crore drawn by it during the period, the same was within the period the same was required to be drawn, and there being no material brought on record that after the drawal of 1 crore against the cash credit limit, the petitioner had approached the bank authorities for modification of the cash credit benefit given to it to the extent of rupees 8 crores, this court is of the considered view that at this view that the claim made by the petition for refund of the processing upfront fee would not mandate an acceptance. Also, accordingly, in view of the above conclusions, the present writ petition is held to be devoid of any merit and the same stands dismissed. Full stop. However, there would be no order as to cost.
But one thing, assisted by DP Bora was here, please do that because he's the person. DP Bora, because otherwise.
Please, what is it?
Assisted by DP Bora.
DP Bora.
Yes, yes.
Mr. DP Bora. DP
And
Bora.
Lordship may add one more line, my lord. Even after dismissal of the case, the learned counsel for the petitioner is going out of the court with a smile.
That is Mr. Nath's quality. I hope everything has come in. I'm not made a mistake in dictating. Huh? First time.
That's a pleasure in this.
First time. The only bank transaction loan I had is a loan when I had taken a house loan. Other than Kima? Yes.
My lord.
Show me. That's what I'm saying. Show me. 227 CRPC? But this judgment will not help you because therein the herein the civil liability was determined. Huh? No, I got it. But here he has refused to exercise discretion. Then what? Will we not have power? Mr. Mahmood, once the discretion is refused to be exercised, would we not have power? I'm just asking you a question.
That is the regional jurisdiction of the Honorable High Court.
Let me examine once. We'll have it on a early date. Let me examine. Because something, let me examine. Because this order I pass will have a wider ramification. Heard Mr.
It may be kept as part.
Yes. He heard Mr. M.U. Mahmood, Learned Counsel for the petitioner. Also heard Mr. S. Chauhan, Learned Counsel, appearing for the respondent. Parties have advanced their arguments. However, the hearing remains inconclusive. Registry to list this matter again on last Hoptatu Agor Hoptatu due. 18/9/2025. In the meantime, let me also examine.
Kindly pass over the matter for the day only. The engaged counsel has been suffering, hospitalized. Engaged counsel Mr. S. Tapadar is hospitalized due to medical emergency.
What happened to him?
Fever and viral infection.
He is having fever for last 3 months.
Yeah.
No, last day. Anything to do with this matter? Because last day also same ground. Illness, hospitalized. And today also, unfortunate.
I'm not the advocate.
Hope he is keeping well.
Yes.
He is otherwise okay. We are having this matter on Tuesday. Kindly ask him to come.
Publish.
Agor order to on the ground of his being indisposed. Birospati vare lagadia. Thursday, 11 to lagadia. Oh, pada here, by 18 to motor day.
Council GN Sahiwala is in Alexandria.
A prayer is made on behalf of Mr. G.N. Savala, Senior Counsel, for an accommodation in the matter today.
Should the matter be passed over for time being? He will do them.
For the full stop. Prayer is not objected to by the Learned Counsel for the respondents.
Time being, can it be?
Naturally.
I think
It's pathetic. Registry to list this matter after 2 weeks on a date to be fixed by it.
Okay.
And we are to blame. Each citizen of this town is to blame for this. It's our actions which are plastics, this, that. If we control ourselves, 25-30% of this will be reduced. Because you don't find water going through the drains. Governmental agencies can be blamed, no doubt about it. But we are also responsible. We start building, if possible, the wall of the house in the middle of the drain. I've seen it. And if we don't, high time if we don't have the civic senses coming back, governmental agencies by itself cannot do everything. We'll also have to be. What are you doing as a pollution control board? Huh? Only with regard to this reports of brick cleans and all you are involved. Why not this issue? Why not this issue? Huh? No, pollution. You don't blast, you can't ban smoke also. But this polluting smoke you can control. Same way you don't ban plastics. But the pollution caused by the plastics is your forte. It's in your ground. Take action. Tell us what you have taken. Who is asking you to ban plastics? You don't have the power. But the pollution caused by the plastics, naturally you will have the power to control. Do it. So that is again your forte. What have you done? I'll have you, the next time I see you here, I'll have a reply from you. Yes, Mr. Sarvania.
My lord, basically during the pendency, my lord, they have paid only my remaining my lord grievances.
Solution.
My lord.
Yes, Mr. Chitya.
Dispose of my lord. Down to exactly similar. Which one looked in that order, my lord?
So secretary to the revenue department is the arbitrator. Same for KAC also. This was a case from
KAC, my lord.
KAC.
And that and on payment of collation.
So what more is required? We'll pass the same order.
That they have withdrawn this also my lord, annexure 8 of this petition that notification dated 23/3/2020.
Party eke hobo ne. Only date to change hobo. Heard Mr. M. Sarvania, so baki sob eke. Para 2 eke. The petitioners are residents of Fuloni Revenue Circle.
Oh my lord, yeah, this
Residents of
Fuloni Revenue Circle, my lord.
Fuloni.
Fuloni, my lord.
In the district, and Mayadepatti has been widening highway number 29, which was earlier 36.
My lord.
3 eke hobo. Demand were not factually correct. An aspect was taken and paid to. In this regard, is drawn the attention of the. Where is your affidavit here? Paragraph would be. Para 4 to Lawson. Mr. Jay Sutia, learned counsel for the petitioner, has submitted that the claim made by the petitioners herein is contrary to the disclosure made from the records. He submits that the due compensation amount receivable by each of the petitioners have been duly assessed, and the amounts so determined has also been deposited by the NHIDCL authorities. The petitioners had also received the compensation amount for the acquired land with due acknowledgement. He further projects that the petitioners had also undertaken to vacate the land and not to make any further claims and objections in respect of the assessment of compensation for the acquired land.
That further claim will be not well justified, my lord.
Also, the said position is, however, disputed by Mr. M. Saronia, learned counsel for the petitioner. R. Pishot, para 5, 6, 7. Who is appearing for the standing counsel? Revenue? Who is here, Mr. Today? Mr. Bordloy is here or Ms. G. Hazurika is here? Huh? No, Ms. G. Hazurika or Ms. N. Bordloy? Who is it? N. Bordloy. N. Bordloy. Eight, 9, 10, 11. The copy of the award you have got, or it is annexed here?
My lord, the annexed.
Annexed.
I have not got the individual word, but they have.
Annexed here.
That can be used as a, my lord.
12, 30. Disposed of.
I love you.
Hey, R. Bora, respondent number 1 and 6. Yes. Work is over. Okay, none appears for the petitioner on call. Mr. P. Nack, learned additional advocate general, appears for the state respondents, along with Mr. P. Hazurika, you are appearing for? So, Mr. P. Hazurika, learned counsel for the appears for the respond number 7. For the ends of justice, registry to list this matter again after 4 weeks on a date to be fixed by. Yes, Mr. Ghosh. Was an email.
Now, there are two cases is there, my lord. One, my lord, this is WPC 6050 of 23, my lord. My lord, pertains to my lord, challenge there. In that case, my lord, the property of the search and seizure. FPDA order. Folding.
Yes, what is your ground?
My lord, now, if your lordship kindly see, my lord, this, as per my lord, they don't have On my lord, a PD order, my lord,
Hmm.
that when a search and seizure is conducted, my lord, there should be independent union, should be present, my lord. My fair price shop, my lord, they should take if their search and seizure, my lord, and they should certify that yes, in my presence, search and seizure has been made, my lord. It is to, my lord, they
No independent witness.
dependent witness, my lord. It was a
Were you available? And you were also not available.
my lord.
Were you present in the place wherein the while this seize and search and seizure was made? Were you present in your shop?
No, my lord, because I was in my lord, the Allahabad, my lord, on that day, because to attend some ritual, my lord.
Where is that report? Seizure report?
Now, my lord will find that place. Place, my lord, 47.
47.
Lord. Sorry,
48.
48. It is in 6053, my lord. Sorry. Not in
6053.
53. Where is the photo? My lord, Lord, you will put it in. Yes, my lord, will season memo, page 55 and 56, sorry. Page 55 and 60. And bottom, lordship will find.
Who is the signature in the last bottom?
My lord, these are the all the my lord, the officials.
Your representative.
Visual representation, my one of the person, my lord. who
You
was
know,
in the
your representative.
Yes, my lord.
Then?
He is not an independent witness, my lord. What?
As it was done in your, where is that requirement for an independent
Yes,
witness? Yes, Mr. Mac, what is your take on that?
Whereas my were there and
What does the rule say? Or the regulation order says? 89 order?
Yes, 82, my lord.
These orders have not been modified afterwards, sir. Mr. Dak, these orders continue to hold the field. Continue.
Yes, my lord, that is provided in my lord, rule 31, my lord.
What does it
31,
say?
It says, my lord, is laid down the procedures, and that said, my lord, the provision of section 100 of the Criminal Procedure Code relating to search and seizure as far as may be applicable to search and seizure. My
Okay, let us see 100 IPC 100. IPC 100.
Yes.
CRPC 100.
CRPC. Yes. That is, my lord, ensure to sanctity of the my lord search and seizure.
That's the only point you have.
In this case, that is the only point, my lord. So on the basis of search and all subsequent action was initiated, my lord.
So if that goes, everything goes.
Yes, my lord. And the next case, my lord, now on the basis of issue the suspension of that, they proceeded the inquiry, my lord. Now, my lord, as per their instruction, my lord, they are now going to cancel my license, my lord, without giving me any opportunity, my lord, of fair hearing. On that, I will submit, my lord, because no document, nothing has been submitted to me, my lord. Whatever document they have relied, in the course of no document has been furnished to me beforehand, my lord.
Hmm?
Four more witnesses, my lord.
Okay. Now, it is insofar as practicable, or that rule says that law
Yes,
was
yes,
a
yes,
section.
my lord.
So your representative was there.
Yes.
Your representative was there. So have you said that the seizure, that the manner in which it was made, you're not supported by your representative? Or your representative disputes that these things were found from your place? Is there anything like that? No. Yes, Mr. What is your case? Hmm. Hmm. Call upon, no. Two independent and respective, no, two or more independent and respective inhabitants of the locality. Inhabitants of the locality. So two independent people from the locality.
It should not be not me, not them.
Hmm?
Not an independent.
Hmm. There is no witness here.
Yeah.
Hmm. Loskor is a inspector.
Yes.
Rahman is an whoever it seems to be. This is an independent. This is a representative of the. It's a person concerned. So he is a person. He cannot be. He is a person. He is the person in charge of that thing now. So he is the affected person. Where is the independent witness? Okay, we'll hear this matter. Find out something. When? There is no stay. There is no stay. We'll see. When? You're not allowed to operate the.
No, my lord. My 90 days period is also over 2 years have gone by, my lord.
When? Tell me.
My lord may fix it.
When? When you
At
want?
the earliest, my lord.
It, yeah, when,
Subject
Mr.
to your lordship convey. That fix it.
Fourth week of September, we are not permitting. It's a motion day. Motion week. Third week. No. 18. Third day, parties at length registered to list this matter again on 18/9/2024 for further hearing.
Well, lordship may take it to other law, my lord. This.
Further hearing, I said.
Nice. Obliged.
Please, your lordship. Some health issues, Mr. Sharma has to leave the court. Due to some health issues, Mr. Sharma is unable to come today, Lord.
Prayer is made on behalf of Mr. M. Sharma for an adjournment in the matter on the ground that he had to leave the court on account of certain health issues. Prayer is not objected to by the Learned Council for the respondents. So registered to list this matter again after 4 weeks on a date to be, no, after 2 weeks on a date to be fixed by. The matter will not be treated as parted and or tied up matter with this bench any further.